Oyez, oyez, oyez. The Honorable Court of Criminal Appeals is now in session.
Please be seated. I'll now call our first case on the docket, AP 77113, in re CHERYL DIXON. Is Ms. Dixon in attendance? Hearing no answer and seeing no indication that she is in attendance as ordered, we will then move on to our, for the moment, to our second case on the docket, number AP-77098, Lucky Ward versus the State of Texas. Would counsel please approach the bench? We will hear first from counsel for the appellant, and we would ask that you identify yourself by name so the recording of this hearing will be easier to track if you'd be so kind, both of you.
Yes, Your Honor.
All right, you may proceed.
Mr. Presiding Judge, may it please the court, my name is Gretchen Sween, and I represent appellant Lucky Ward. Mr. Ward was convicted and sentenced to death in Harris County in March of 2020. This was nearly 10 years after his arrest, at which time he confessed as a mentally ill homeless individual to having caused the death of his friend, another homeless individual, Rita Long. That confession was captured on videotape in the police station, but the state relied on its theory of capital murder on Texas Penal Code 1903A7B, which requires proof of two different murders in two different transactions involving the same scheme or course of conduct, which this court has had some recent familiarity.
The statute is a little broader than that, though, isn't it? I mean, it allows conviction upon demonstration of multiple murders, right? Not just two.
Correct, Your Honor. It can be more than, it's more than one is the burden of the state, but there must be, when they're not part of the same criminal transaction, they have to prove this same scheme or course of conduct. And it is our position that they did not even articulate a legally cognizable common scheme, nor did they adduce legally sufficient evidence of the second murder that was the charged offense, the murder of Carlos Rodriguez, a transgender individual who was found dead in his home following or during a sexual interaction. So there were two murders, one to which Mr. Ward had confessed and which provided the state all the information they needed to obtain a conviction, and then one he vehemently denied having any role in, although he also volunteered to the police that why his picture was on the camera of Rodriguez, which was found in Rodriguez's.
What is the issue? What are you arguing here? I mean, how many issues are there in this case, and what are you arguing?
This is an excellent question, Your Honor, and I appreciate the chance to pivot. Part of the problem here is this case is so larded up with error, it was very difficult to designate issues that I would like to discuss in the limited time I have, but that is irresponsible. So I will quickly say I'd like to start with points of error 10 through 22, which involve Mr. Ward's competency to be tried. Even though it took 10 years for the state to come up with evidence. And
that's kind of why I asked. I'm like,
yes,
you're telling me all this
yes,
stuff about different
right,
reducing things, but it seems like competency is
But there's this paradox here that I'm suggesting there was a rush to trial when Mr. Ward was showing overwhelming signs of incompetence. But part of this delay was this effort to find evidence to support a theory as opposed to evidence leading to a theory. So Mr. Ward showed overwhelming signs really throughout this 10-year period that he was a person with serious mental illness, well documented. He was a guy that MHMR had designated as disabled because of his mental health issues. He had a monthly disability check. Lots of evidence of mental illness, yet he was never properly assessed for competency. He was excluded from most substantive pretrial hearings because of comments made about how he wasn't capable of being there. And he was excluded from a chunk of voir dire, which is against statutory law. And he was excluded from much of his trial, not because of a voluntary waiver, but because he was showing these flagrant signs he was incompetent, and there was a reluctance on the part of the court to pause and figure out what was going on. And as Your Honor is very aware, we have this wonderful statute, Chapter 46B, that the legislature took great pains to craft after years of recognizing there's a real problem in the criminal justice system of mentally ill people being tried while incompetent, and that judges and lawyers aren't necessarily trained to recognize the complexity of mental health issues that interfere with their ability to rationally engage with counsel and to comport with social norms that are expected in the courtroom. So we have this great statute, and I've provided Exhibit 1 to the oral argument, which includes a flow chart that appears in bench books provided to judges to help them, because this law was seen as so innovative, but it's, again, not intuitive. It requires, it's mandatory, that once you see suggestions of competency, you stay whatever the proceedings are and then follow the flow chart. Here, as outlined in points of error 10 through 22, virtually nothing about the statute was honored. We have Mr. Ward coming unhinged during voir dire.
I
Yes.
want to slow you down a little bit. You mentioned this flow chart is an exhibit, and so to some degree, is that in the statute itself, the flow chart, or is that something that someone else created in order to help other people to understand how the statute should work?
Judge Urey, it's the latter.
Okay.
And as we noted in a filing, there was an objection to the exhibits, that this is not part of the statute. It is a demonstrative exhibit of the statute that is prepared for a bench book.
Do we know like who prepared that, or is that?
This one is from the 2019 version of the Texas bench book on mental illness. And in my filing, I said it's,
Is that
it-
right? Prepared for trial court judges to follow?
yes, Your Honor. And I believe that the Honorable General Counsel,
Judges,
I'm sorry, for,
by other judges, presumably.
I'm sorry.
The bench book is drafted by whom? And it's not subject to bicameralism and presentment. It is not approved by the House, the Senate, and signed off by the governor, correct?
That is correct, Your Honor, but for instance, a member of the General Counsel of this court was on the committee that prepared the bench book, the most recent version published in
And I'm
2021,
sure
which has
it's-
the
I'm
identity.
sure it's very well written, but the question that's coming to you from someone is going to be, would departing from it violate the law?
And Your Honor, I would say yes, because the statute is replete with mandatory language, shall, must. And as this court, in a unanimous decision in another death penalty case of Damon Blunson, made clear, once there is some evidence, and that is a low bar, one must stay the proceedings and follow the statutory guidelines, which include, once there is some evidence, and one is only allowed to consider evidence of incompetency, not competency, then there must be appropriately appointed experts to do an exam per the statutory guidelines. You have to have 30 days minimum to review collateral sources, do the assessment, provide a report. None of this stuff happened. You had,
competency hearing before the trial started?
Your Honor, there was, in the middle of voir dire, when the client,
Not before the trial, was there any type of competency hearing requested before the trial started?
no, what is bizarre is in the record, there are a couple of, in the clerk's record, a couple of these forms suggesting that a magistrate requested a mental health evaluation, but there's no record it ever happened, no report as mandated by law. What we have over the years are lots of comments on the record about Lucky Ward's mental health, about, for instance, him thinking he's being poisoned and losing a lot of weight. He himself, the few times he was allowed to come to court, talks
My
about,
question is, at what point was there ever a competency hearing for this defendant?
it's our position, there never was. There was no competency hearing. There was a hearing.
Was there a hearing where a judge presided over a hearing and made a finding that he was competent or incompetent?
What happened, Your Honor, is that
Just
during
yes or
voir
no?
dire,
Okay.
there was a meltdown, and counsel asked the judge, begged the judge to stop. Their client attempted suicide in the holdover cell. Things had gone crazy. They said they could not rationally communicate with him. And the judge, and this is important to recognize, had been brought in to cover voir dire. She had not been a part of this case for the 9 years before. She says on the record, it's not uncommon, and especially here where you had a judge who had been elected and had no known criminal law experience. And so she was going to, this experienced judge, come in to cover voir dire. She makes comments about prior competency evaluations. And the defense says, we're not aware of any. Because in fact, there weren't. There was never a time. There were suggestions of incompetency made in documents, in court records, but no evaluation. When she finally is told, you're about to inject error into this case under Turner, if you don't pause, she stops voir dire, but Lucky Ward is not there, then continues to interview jurors outside his presence, but then appoints, this is Friday,
Like,
a judge, a psychiatrist.
She continued jury selection?
Yes.
With the defendant removed?
Yes, she did. After he'd been removed, she continues to hear excuses. She doesn't do individual voir dire. But part of what is in Exhibit 2 is a demonstrative of all the known times Lucky Ward was not present and there was no voluntary waiver. And that includes parts of voir dire. And I've had some, there's differences in our briefing about how many jurors were excused.
So we deviated, getting back to my original
Yes.
question. Was there ever a competency hearing at any point before or during the trial?
During voir dire, there was this pseudo drive-by competency hearing where over the weekend she sent in a conflicted expert who admitted on Monday morning he'd not yet reviewed records. He'd just been given some records from the jail that morning. He had never met with Lucky Ward, but he was willing to say he was competent based on talking to some jailers. That was it. There was no examination by the defense or even the state. Meanwhile, the defense had also obtained funding to get their own expert appointed. And he had not yet, he wanted to, he was not able to appear in person. He asked to appear telephonically. The judge denied it.
Because I've participated in several competency hearings. You stop the proceedings, there's a judge, whether it's the trial judge or another judge is referred to him. There are witnesses that testify, and after it concludes, then there is a finding of either competency or incompetency. Did that ever occur in this case?
What Judge Bradley concluded, after there was one witness, the witness who never met with Lucky Ward, and then the defense was not able to put on their expert because he had not either had a chance to meet with Lucky Ward. So on Monday morning, she asked the defense, are you willing to proceed? And they say, well, we are, essentially waiving the competency inquiry. And then she pushes them to say, well, do you think he's competent? And they say, they sort of talk around the issue, but they say he's competent to decide not to testify. And then they put on the record a whole bunch more evidence he's not really competent during the course of that day. He's not there in the morning proceeding, and then they bring him back at some point, and he's drugged so much, they put on the record that he's falling asleep and he's not able to talk to them.
I guess the answer is no, right?
The answer is no.
That's all.
It's just, Your Honor, and I apologize for all the complexity. I think Judge Bradley believed she had made a finding of competency, but there was never really a full hearing, let alone the formal trial that the statute mandates, as this court recognized in Blunson, that once you acknowledge there's some evidence and you appoint a psychiatrist or psychologist or a mental health professional who's qualified, once you make that admission, you have to follow the statute, mandatory that you end up with a trial unless both parties agree that the defendant is incompetent. And that process was not filed, and it's mandatory. And back to your question, Judge Shank, this all stems from decades-old Supreme Court law that says there is a substantive constitutional right not to be tried while incompetent. And the reason is because there is a fundamental right to be present and confront those who accuse you. And if you are mentally incompetent, you're being deprived of your right to be present. So this goes back to Dusky, Pate versus Robinson. And what the Supreme Court dictated to states is you need to come up with adequate and fair procedures, due process, to protect this substantive federal right. And Texas's solution to that is Chapter 46B, and quite the admirable state law that shows judges what is mandatory to protect due process. So Mr. Ward didn't get that. He didn't get the due process, and therefore we have no way of knowing if this substantive right not to be tried while incompetent was robbed. But we have a lot of good evidence because he missed most of his death penalty trial.
We did have a question, though, as you pointed out a minute ago, to his counsel from the bench of, is he competent? And the answer, the judge asked his counsel, is he competent? And the answer she gave was yes, right? So
The judge asked.
What's triggered as against that backdrop? I understand the chart and best practices are to follow the chart, but what's a judge to do when the judge asks the right question and gets the answer from his counsel that he is in fact competent?
Two things, Your Honor. First, we look back to Drope, one of those seminal Supreme Court cases on competency. And in Drope, the Supreme Court makes clear that while you need to rely on counsel to inform you as a judge, you do not abdicate your responsibility as a judge ever to ensure the defendant is competent. And that's why in Drope, we had a similar situation of the defendant attempting suicide during trial. And the argument was, well, that he brought it on himself. So too bad, so sad. Supreme Court rejected that. Also, this court in Blunson rejected that implicitly, because in Blunson, same thing happened. The counsel are like, never mind, we take it back, we feel he's competent, we can go ahead with trial. And this court said, no, the statute means what it says. And so judges do not have any discretion to simply ignore the statute that took years and a lot of bipartisan and interdisciplinary work to craft. And I see I'm about out of time, and I never got to 404B. I want to say real quickly that I know Judge Keel is very aware of the analytical process because of Velades that you decided in 2022. Three-prong analysis. None of those were satisfied in this case. There was not, beyond a reasonable doubt, proof that Lucky Ward had anything to do with Carol Flood's murder. There was also no need on the part of the state that is legitimate unless you overrule virtually all of this court's 404B jurisprudence, because identity of a perpetrator, using an extraneous to prove that, requires nearly identical fact patterns. We don't have that with Rodriguez and Flood.
Where's the harm there? It's happening in guilt innocence, right? The evidence is coming in. It is odd to me that you would have an unadjudicated prior bad act with something potentially less than preponderance of evidence tying this defendant to that act. So the harm for the other two, frankly, to me seems fairly low in terms of guilt or innocence, but there's a high risk that that error, if it's error, washes over into the punishment phase, where you have an unadjudicated, unproved additional murder, potentially, that was put in front of the jurors during the guilt innocence phase.
And Your Honor, if I may,
Where's the
I think
harm?
I'm
Go ahead
out
and
of time, if I may respond.
Yeah.
I think the harm is actually far greater in guilt innocence because there was such insignificant circumstantial evidence linking Mr. Ward to Rodriguez, and then virtually no competent evidence, really none, that he was responsible for Carol Flood. So by injecting that, you blind the jury, and as this court said in Ridgely, an extraneous murder in the guilt phase, the prejudice is almost self-evident. It certainly had very little probative value. Carol Flood's tragic demise doesn't get you any closer to proving who killed Carlos Rodriguez, because there's nothing in common in the two crimes.
Before you go, what do you see as the threshold, let's say a conditional relevance threshold under 404B to get evidence of the other strangulation because of the fact that he'd given her the scarf, to make it probative of anything relating to the other murders? at a minimum, does there have to be proof by a preponderance that he did the unadjudicated, uncharged murder? Does it have to get to that level before it should be admissible? to
What
prove
you're-
common scheme or technique?
What this court has said over and over is there must be proof beyond a reasonable doubt of the extraneous. So that's, first you gotta prove that. They did not satisfy that, and there's been a lot of loose language about DNA in this case. There was not DNA, there was YSTR results from a mixture involving at least 3 people, including 2 males. How you even do YSTR testing when you have 2 males, I don't know. But that was what they had on a scarf that had multiple people's DNA all over it. It was a scarf a homeless woman had, who knows where she found it, it was found in the streets of Houston. I'm telling you, I touched this podium, I may leave my DNA here. Opposing counsel comes up, touches the podium, she may take my DNA and then go back to Houston in her car, leave my DNA on the steering wheel mixed with that and her kids and whatever. That doesn't prove I was in her car. The scarf is not dispositive of anything, and plus there was multiple DNA on that scarf, multiple people, in a community of homeless people where Lucky Ward plainly, he was sleeping in the streets, as was CHERYL Flood, going to the same shelters. It's not at all proof of guilt of a murder.
There are a lot of also a lot of similarities between these. I mean, sort of similar time frames, similar places, similar manner of death. A lot of other like sexual things going on right around the time of death. So there's a lot of beyond the DNA, right? There's a lot of other facts that seem to connect these murders.
And Judge Erie, we would respectfully disagree in that if you look at the facts, and there's a summary in a demonstrative Exhibit 3 of the basic factors of the Rodriguez case and the CHERYL Flood case. The only similarities, and the state really had to stretch at trial and talk about strangulation in Houston. Like this isn't sufficient, this isn't what is in this court's 404B cases. They're signature crimes.
What is the full time frame from the earliest murder to the latest murder?
Mr. Rodriguez died on September 15th, I believe. And read along September 30th. And CHERYL Flood was, I think, October 10th.
So, I
But
mean,
in-
it's less than a 2-month period of time. I mean, less than a 2-month period of time, you have all these strangulation murders. How many strangulation murders happen in a year
Well, and
in
this-
that same area of town? I'm curious. I don't know.
And Your Honor, that is an excellent point. And one of our other points of error, clearly not designated for today, is about how the defense was deprived of a chance to put on that very evidence. They had obtained a spreadsheet from the Houston Crime Lab of all the strangulation deaths in the Houston area over this period, including all the years Lucky Ward spent in jail, and there are numerous ones. And if you start reading the 404B cases out of this, you find strangulation is not an uncommon, unfortunately, way for someone to die.
Counsel, quickly, very quickly. Why would these be generic instead of signature?
Your Honor, in the CCA case law, if you look at them, it's like even having the semen of a perpetrator in a victim in 2 different crimes has been seen as insignificantly similar. Even when these were both women who were assaulted in the same town and in the same, the person broke in at the same time.
But in this case,
in
why
this
would you
case-
say they're generic instead of signature?
Because Mr. Rodriguez died, we know, of strangulation, and the autopsy report suggests it was neck compression because there was very little trauma to the neck. There were some red spots on his neck when his naked body was found. After his roommate reported he had had a sexual encounter with a bald, muscular black man. Miss Flood was a 60-year-old African-American homeless woman who died from ligature strangulation with a lot of violence. There was trauma to her head, there was trauma to her vagina, was half naked, very different crimes. This is not signature handiwork Mark of Zorro, the kind of language this court has utilized in these identity cases where 404B has been seen as appropriate.
Okay, counsel, I think we have that argument. You have some time for rebuttal. We'll look forward to
Okay,
hearing.
so sorry, Your Honor. Thank you very much.
Good morning, and may it please the court. My name is Patricia McLean with the Harris County District Attorney's Office, and I represent the state in this case. I'm going to jump right to the extraneous issue since that's the last topic you all covered. The trial court did not abuse its discretion in admitting evidence of Carol Flood's murder in the guilt phase under Rule 404B and 403, but the focus, since y'all focused on 404B, I'll start there. First, the trial court properly did find that any rational jury could find that appellant murdered Flood beyond a reasonable doubt. And to Your Honor's question, that is the standard. Is the question that the reviewing court asks is, yes.
When you said that this could be beyond a reasonable doubt,
Yes.
okay? Are you saying that some jury may do it? Are you saying that this is really evidence beyond a reasonable doubt? Because I can't see that.
Yes, Your Honor. I'm saying both. The standard for review, as you all know, admitting an extraneous is under an abuse of discretion standard in the first place. So there is some deference to the trial court's findings on this. And the necessary question is, would a rational jury have necessarily entertained reasonable doubt in finding appellant murdered Ms. Flood? And that's not the case here.
Is it any rational jury or just a rational jury? Because a lot of juries aren't really rational.
The standard, Your Honor, is any rational jury, Your Honor.
Well, what, we need to review that, and what was there to support that conclusion that we could cite in our opinion if we were to agree with it?
Yes, Your Honor. First, which y'all touched on earlier, the DNA mixture on the scarf. Mr. Ward cannot be excluded as a possible contributor to YSTR DNA mixture on the scarf. And it's important.
Didn't he give her the scarf?
He actually, that's one of my other points, Your Honor. He, at first, when Officer Cisneros was interviewing him, appellant said he didn't know Carol Flood, he didn't know anything about this, he didn't remember anything about it, didn't know anything. And Cisneros went to go find a better picture of Miss Flood to see if appellant could recognize her, which he was unable to do. When he came back, appellant asked to look at the same picture Cisneros had already showed him, and at that point he admitted, yes, actually I do recognize her, and he admitted that he gave her the scarf at some point. And back to the DNA.
And counsel, how many days did the state spend telling the jury about this extraneous murder?
There was one full day of testimony, and then the following day, Officer Cisneros, there was brief testimony from him about appellant's confession, or his interview about Flood's death, and also he also testified about the similarities between all three of the cases. So a little over a day.
At least one full day and part of another.
Yes.
Okay.
Out of a 7-day trial, yes, Your Honor.
Yeah, and when you say a 7-day trial, that's 7 actual days. So you're saying there was 5 days of testimony that wasn't related to this extraneous murder?
I'm saying there's more than 5 days. That's unrelated. There's 5 and some change, and there was also an extraneous offense hearing an additional day, but that was outside the jury's presence on this case. They had a full hearing to see on the admissibility issue of the extraneous, Your Honor.
And wouldn't you think that spending more than a full day of testimony on an extraneous offense is a little overkill?
No, Your Honor, I disagree. And that, to the 403 point about consuming an inordinate amount of time, this court has held, I believe it was Page or Lane, I apologize, it's in my brief, that essentially spending a little less than 1 day out of a 5-day trial was not an inordinate amount of time to spend on an extraneous. So this was roughly about the same time. It's about 1/5 of the entire trial. It was about 1/5 of the entire record, and much of the evidence, it was the same type of evidence. There's a lot of DNA evidence for all 3 of these victims, And Cisneros and the DNA analyst, Robin Guidry, testified to the instant offenses as well. So there was repetition of, it wasn't all new witnesses, that kind of thing.
And isn't it true that the state waited till the very end of question and answer to get into the extraneous?
Yes, it was after the state presented evidence of Ms. Rodriguez's murder and Ms. Long's murder, and at that point, they moved for the extraneous hearing due to defense counsel's cross-examination and the evidence that they admitted, their own affirmative evidence admitted that raised the issue of identity in the Rodriguez case and lack of accident or mistake in the Long case, and then that's when they had the hearing.
So the very last thing the jury got to hear was this extraneous offense, which was a murder.
Yes, Your Honor, it was another murder. It was prefaced before the jury heard anything. The trial court gave a limiting instruction as to both, as to how it should be applied, that it needed to be found beyond a reasonable doubt, of course, before it could be considered at all, and if so, only for those specific purposes for each of the charged victims. And then that same limiting instruction was given in the jury charge as well.
When you were answering Presiding Judge Shank's question a moment ago, I was going to try to track what you said because I think he asked you what evidence would convince us beyond a reasonable doubt, and you began
Yes.
by saying there's some DNA.
Yes.
And beyond that DNA evidence for whatever value it had, what else was there?
Yes, to get back to that.
Yes, thanks.
Not just that there was DNA that appellant could not be excluded from, but the specific location of where that DNA was. Specifically, it was on the scarf, and it was on a loop that extended from a twisted portion at the back of her neck, which essentially the person who strangled her would most likely be holding that exact spot when he strangled her. So that's an important fact as well.
And it's not certain that that's the defendant's DNA.
No, it's not.
possible.
That's right. And for the YSTR testing, the power of the statistics are different than autosomal testing. However, what the DNA analysts testified to, even for the YSTR analysis, the combination of YSTR profiles was only seen in their reference database about 0.2% of the African American population they had in their reference database, 0.3% in the Asian population in their database, and 0% in any other population in that database. So it was a low number even for the YSTR statistical power, or the results.
And in your opinion, that's proof beyond all reasonable doubt.
No, Your Honor, I'm saying that in conjunction with where the DNA was on the scarf, appellant changed his story about how he didn't know her, and then he later said, well, yes, I did, and he admitted he gave her the scarf. Miss Flood was found in an area near where appellant frequented and where he slept, and he also admitted that he, 5 blocks away where Miss Long was murdered, he admitted that he spent a lot of time with her at that location. However, despite all of that, he told Cisneros that no, he had no idea where the YMCA was, he had no idea where the cross street was, even though it was very near where he frequented, where he slept, and where he spent so much time with Miss Long, where he admitted that.
Counsel, so was there other DNA on the little twisty loop thing you were talking about besides?
It was
Mr. Ward?
YSTR mixture for
Okay.
the minor component.
So there
And
were
then
there were two other contributors in that? as
No,
well?
just 2 males for the
Okay,
minor.
So presumably Lucky Ward and then another person we don't know.
But,
Okay.
correct.
And then
Yes.
now I kind of want to shift to the competency issue because
Yes.
it doesn't
Of
mean,
course.
it doesn't matter. All the rest of this doesn't matter if he's not competent. Would you agree?
Correct.
All right, so beyond defense counsel's, I think you two would probably argue about how strong this was, but beyond defense counsel's assertion or belief or whatever you want to call it that Mr. Ward was competent, what is the best evidence that Mr. Ward was competent during his trial?
And that actually goes to your questions earlier. Yes, there was an informal inquiry during the trial. During voir dire, the judge engaged in an informal inquiry, which is the preliminary step when a suggestion of incompetency is raised. That suggestion of incompetency was raised during voir dire. That was the first time a suggestion was
By the
raised.
judge or by the defense?
It It was by the defense attorneys. They requested a competency eval in the middle of voir dire after appellant refused to come sit in the courtroom. He was expressing paranoid thoughts. He thought the judge was biased and the prosecutors were coaching the jurors, and he didn't like that there were law students observing. And he wanted to go back to the jail, and when the judge told him, no, sir, you're gonna go to the holdover in case he changed his mind, he went there, and that's when he tied a sock around his neck, and at that point, defense counsel came out and moved for a competency eval.
Finish answering this question, and then I'll ask, I have a couple of questions on the competency.
Yes, sir.
Go ahead.
And to get back to that, so after that, the trial court appointed a courts expert, Dr. Mahler, to evaluate appellant, and also granted the defense's request to have their own expert evaluate him. Dr. Mahler, appellant refused to talk to him, but Dr. Mahler testified on the following, a few days later. This occurred on a Thursday, and the testimony happened on a Monday. He testified that he reviewed the most recent medical records for appellant. He talked to the jailers who took care of him, and he reviewed the defense's motion and the other information that they provided to him in making his assessment. And after he testified that he opined that appellant was competent, the judge found him so and proceeded with the general voir dire of the next panel. And after that concluded, the defense's expert evaluated him as well. And the following day, the defense confirmed to the court that, yes, he was also evaluated by his own expert as to competency, and they stated they had no further issues. He has remained competent, and they moved forward.
And how long was he in jail before the trial?
It was almost 10 years. He was arrested in November 2010.
And a lot of things happened during that time that would make a normal person think that this guy has some serious problems. Is that correct?
The main thing that was raised was the motion to withdraw in 2014, so about 6 years before the trial. Former defense counsel Geiser moved to withdraw, and in that motion, at the time, Dr. Mahler, he had reviewed records, and they had hired him to examine him or to interview him, whatever, as a defense expert.
Dr. Mahler reviewed the most recent medical records. He didn't look at all these medical records for the 10 years, did he?
No, he did not, and he doesn't need to, essentially, because the question, the relevant inquiry for competency is your status at the time of trial. So lengthy history, it's not as relevant as the 3 months before, which is what Dr. Mahler did review and consider. So that's the question, is at the time of trial.
He didn't actually see the defendant. He didn't go see him at all, did he?
No, he tried for about an hour and a half to talk to the defendant, and the defendant refused to talk to him. But Chapter 46B does not require that a competency eval include an interview with the defendant. And specifically, the statute actually contemplates that there are situations where a defendant will refuse to talk to an expert, as in the statute, I believe it's 46B, it's either .024 or .025, that the expert cannot base his competency determination on the fact that the defendant refused to talk to them. So it certainly contemplates there are defendants who will not cooperate, and there's other ways to conduct an evaluation.
When you're saying that the defendant refused to talk to him, did the defendant sit in front of him and then tell him he's not going to talk to him, or was this second or third hand information from some jailer that said no, he didn't want to talk?
I am not entirely sure how it happened. In the record, he says I think they tried to get him out of his cell to talk to Dr. Mahler for about an hour and a half, I believe is what he testified to, but appellant refused, is my understanding of the record of it.
Counsel, I've got a question for you.
Yes, sir.
If I understand this right, on the chip back to the 404B for me,
Yes, sir.
the state had to show, in terms of between the Rodriguez and the Flores murders, that the modus operandi in which the pattern and characteristics of the charged crime and the uncharged misconduct are so distinctively similar that they constitute a signature. Would you agree with that?
Yes.
All right. Rodriguez was a 35-year-old biological male, and Flood was a 65-year-old biological female. Just addressing those two, how does that create a modus operandi in which the pattern and characteristics of the charged crime and the uncharged misconduct are so distinctively similar that they constitute a signature.
Yes, Your Honor. And in addressing that, it's important to note that while they need to be very distinctively similar, there is no requirement that they be identical in order to be relevant to identity, to start there. Again, this is an abuse of discretion standard, and the question for signature cases or identity cases is whether the pattern and the characteristics are so similar as you stated. And that includes, as this court said in Segundo, the accretion of small, sometimes insignificant details, including the mode of commission of the crime, proximity and time and location, or any other elements.
Would you characterize gender and age as small, insignificant details?
I would characterize them as details, but it's important to note for those two particular details, number one, they're both adults. This isn't an adolescent and a child and an adult. And as for Rodriguez, she was biologically male, but she was a transgender woman. She identified as female, and she held herself out as female, and she even dressed as female, as her friends testified to. And even when Appellant met her, when she took their pictures, she was dressed as a woman. Just to those two specific factors that you were talking about, Your Honor. But in addition, for the signature question, considering things like Appellant's links, as I stated earlier, he frequented the area near where Ms. Flood was found murdered, and also it's also where Rodriguez liked to go, the Montrose area where she would go to clubs. And let's see. He also admitted to police that he interacted with both of them. So he had met both of these murder victims before they died. He gave her the scarf at some point, as I stated earlier, and he, again, like Ms. Flood, Appellant cannot be excluded as a contributor to DNA found specifically on Rodriguez's neck.
What's the specificity of that cannot be excluded?
For that one, that was autosomal DNA testing for the Rodriguez case, so the statistics were much, much higher than for the YSTR testing, Your Honor.
Can you honestly say, in your opinion, that this sounds like a signature to you?
Yes, Your Honor. Yes, Your Honor. And the trial court certainly didn't abuse its discretion in finding as much. In addition to the links and the victim characteristics, which I'll get into a little more in just a second, the actual mode of the commission of the crimes is very similar for both of them. Ms. Flood died of ligature strangulation, and Ms. Rodriguez died of strangulation. That was her cause of death. It also included ligature marks, and her death was consistent with ligature strangulation. And multiple witnesses, multiple investigators, and the medical examiner all testified that strangulation homicides are not common. So moving on from there, not only were they both strangled, but they both had fractures to the structures in their necks. They were both found in varying states of undress. Ms. Rodriguez was nude, and Ms. Flood, she was only dressed from the waist up. Sexual activity or assault occurred near in time to both of their deaths.
Oh, wait. Can you direct me in the record where the state introduced any evidence that Flood had recently engaged in sexual activity?
Yes, Your Honor. The medical examiner testified that she had tears to the entrance of her vagina, and he testified that those likely occurred near in time to her death. They were both victims were not found just out in the open. Ms. Rodriguez was found in a duplex that she shared when she stayed there with roommates, and the door was actually left open, so it wasn't left locked and sealed. And Ms. Flood was found next to the YMCA on the stairway that's encased essentially on three sides by a wall and the building itself. So they're not just totally open and exposed to public view.
Were there any similar marks on Rodriguez? I mean, I understand Rodriguez is a biological male, but you seem to put quite a bit of weight on what you referred to as marks around the entrance to the vagina, bruising or tearing. Was there any trauma to the other Rodriguez?
No, Your Honor, but the roommate Sosa testified that when he came down before he left for work, he heard, before he came downstairs, in the hours before Rodriguez was found dead, he heard noises that sounded like oral sex.
So wouldn't that suggest, even under the best of interpretations for the state, that these two dissimilar or similar? One was a rape and one was consensual? Wouldn't that weigh against the state's?
Right, and I'm not suggesting that Rodriguez was sexually assaulted. It's just there's some sort of sexual activity that, consensual or not, that occurred before their death.
Right, but my question is, you put that forward, the state has put that forward as evidence that these two murders are distinctly similar. But if that evidence is interpreted literally, wouldn't it suggest that one was consensual and one was not consensual, weighing against these murders being distinctively similar?
I think it's going to depend on, number one, you still have to look at it through the abuse of discretion lens, and the context is sexual activity, whether consensual or not. And in light of all of the other factors or the other similarities, which also include there were items missing from both crime scenes, the murders happened less than 1 month. Oh, I see my time has expired. May I briefly?
I have a question when you're done.
May I conclude, Your Honor?
Please, go ahead. He says go ahead.
Okay, thank you. Yes, both murders occurred about 27 days apart. And both of these victims, the last factor of similarity between the victims themselves is due to their life circumstances, their lifestyles. They were more prone to encounter people that they did not know very well, whether by bringing different partners home, as Rodriguez did, and she didn't have a consistent living situation, and of course, Ms. Flood, who was homeless as well.
So one of the things that is occurring to me is that all of these individuals, and correct me if I'm wrong about this, because I want to know whether I'm wrong about this, but it seems like they all had interactions with the defendant.
Yes.
I mean, there was a confession to killing Long. There's an indication that Rodriguez had interacted
Yes.
with the defendant, and there's also an interaction with Flood, right?
Yes.
Because he admitted that he knew her and maybe gave her a scarf.
He remembered her. He admitted he gave her the scarf at some point. Yes, Your Honor.
So this is just maybe an off-the-wall question. That's just something that I've remained curious about for a very long time, which is, have you ever heard of the doctrine of chances?
Yes, sir, I have.
And so I'm wondering, is that real? Is it something that courts can draw real conclusions from? And if it is true that they could, then what applicability would that have in a case like this? How would we rely upon that, if at all?
Yes, Your Honor. The doctrine of chances, it's very similar essentially to an identity case or an identity issue, because basically the underlying question is, what are the odds that this would happen with the same person and same involvement? Although the doctrine of chances is not specifically in 404B, this court's already stated that it's not an exclusive list. There's other ways that you can get into 404B extraneous evidence. And the few cases I saw in doctrine of chances, it also required a very high degree of similarity to get in. So
we're looking at the same kind of analysis.
essentially, it's the same. They're just so similar. They share so many significant similarities, and it's not a matter of picking one or two at a time. It's looking at everything together, which this court said in Segundo you look at when you're analyzing for a signature analysis.
Thank you very much.
Thank you. Thank you, Your Honor.
If I may start at Segundo, because the state mentioned this case several times. This is a capital murder case in which the primary offense was a rape murder in which the defendant's semen was found in the vagina of the victim, and the extraneous offenses were rapes in which the defendant's semen was found in the victim's. And this court, in a very reasoned decision, was careful about the fact that with this kind of identity use of extraneous, that kind of DNA is like the mark of Zorro. Single source male DNA from a biological substance that was very inculpatory. That is not what we're talking about in this case. And there's been a lot of loose language here. With CHERYL Flood, this YSTR result that the state's own expert, and they spent about 5 minutes on this, she said this is a last resort. There was very little discussion about what this is, but it was a mixture of 3 or more people, including 2 males. It was not a mark of Zorro. Also, the scarf business. The only evidence that Lucky Ward gave her this scarf, and that's not even what was said, was Detective Cisneros said that after he turned off the video, Lucky Ward said, let me look at her picture again, and said, maybe I saw her at a homeless shelter, and maybe I touched something. That's what he said. He didn't say I gave her the scarf. This was speculation, and this also is hearsay coming from the detective who admitted, well, he could have turned the recording back on. He'd spent hours recording Lucky Ward, and he didn't. But it's not inculpatory.
But is the giving of the scarf the issue, or is the DNA on the back of the scarf more of the issue?
Again, Your Honor, it's not a single source male profile. It's a proof that that a male with a Y chromosome cannot exclude Lucky Ward's one chromosome. But there's another male in that mixture, and this is really sketchy stuff that they spent years trying to come up with. It is not beyond a reasonable doubt. And, you know, back to your very smart question, none of this matters if he was incompetent.
I have a question for you along that line, because I agree with Judge McClure. What does the record reflect to show that there's some evidence at the informal inquiry of the defendant's mental illness?
Your Honor, he first of all tried to commit suicide in the holding cell after he goes into this rant based on his paranoid delusions that the judge is in cahoots with the prosecutors and secret bloggers in the jury box and text messages being sent to them to tell them how to answer. He goes into this rant, and either the state is suggesting that was totally rational, or that's a significant indication the man was not competent. And then he spends most of the trial back in his little jail cell where the judge sends the guards to videotape him. If you look at these videos, you don't see a man who is rationally equipped to engage with counsel or potentially testify. You see a guy out of his mind. And this is why Chapter 46B exists, is so lawyers don't have to try to figure this out. They can get help from professionals. This appointed expert was conflicted. He didn't provide a report. He wasn't even clearly qualified, and he went in over the weekend and they couldn't get Lucky to calm down.
Well, how could you get better? What psychologist are you going to find to treat the person in order to make them competent in order to stand their capital murder trial?
Your Honor, that's an excellent question, and 46B has a lot to say about that. That part of what's supposed to happen is everybody pause, you get the truth, and if you have an incompetent person, there are procedures for restoring competency so that they then can actually be tried in a constitutional proceeding and not something that makes us look like a kangaroo court.
Do you feel like that the defendant's mental illness interfered with his ability to participate in this trial?
Absolutely, Your Honor. And this is not this. The defense itself ended up putting on in punishment a mental health expert who described Lucky Ward's long, well-documented serious mental illness of bipolar, schizoaffective disorder, schizophrenia. These include diagnoses made by TDCJ, by the jail, long history going back to his teenage years.
Was he used to establish his incompetency?
No,
Why not?
no, because his lawyers, I can't say, but it looks like they were exhausted. They got a hostile judge who wanted to move forward, said that over and over, and they gave up. It was too difficult to deal with their incompetent client. They just wanted the trial over.
Have you challenged counsel's effectiveness in this appeal?
Your Honor, I have not, because it doesn't tend to be successful in direct appeal, but I suspect that might be something that's coming later. And Your Honor, if I may, one statement about the 404B. I know you're going to do a legal sufficiency review. It is very important not to play fast and loose with what the evidence actually was. Again, the only single full male DNA profile from which Lucky Ward could not be excluded that was introduced by the state was DNA lifted from the passenger door of Charlie Rodriguez's car. And that is completely consistent with what Lucky Ward himself told police about how they had this interaction in a parking lot in Montrose where Rodriguez was going out clubbing and Lucky Ward, homeless guy, was trying to hustle for a tip and said, "I'll watch your car." It's not doctrine of chances. This court's great opinion in Delaz Paz talks about that doctrine. it has to be, again, virtually identical. And again, in that case, you had a buy or bust drug setup situation with a cop, where there was no doubt that the guy had done it multiple times, and then in this trial, they wanted to introduce it because yet again, same pattern. This is not that case. Thank you, Your
Thank you
Honor.
very much. The case will now be taken under submission. I'm going to ask if we now have in the courtroom CHERYL Dixon. Is she here? Could you approach, please, Ms. Dixon? Come right up. Ms. Dixon, do you have counsel with you here today?
No, Your Honor.
You are the CHERYL Dixon, the court reporter who has been working on the capital murder conviction of a gentleman by the name of Cedric Marks. Do I have that right?
Yes, Your Honor.
I'm informed that the record for his appeal, he would like to appeal his capital murder conviction and his sentence of death, was due originally on October 9th of 23. The record is not prepared at this point, is that right?
Correct.
Okay. Now, I've got a lot of materials that have been handed to me about efforts to get the materials presented. I understand that you've had a number of communications with court staff and with the trial court staff, is that right?
Yes.
There are a total of 7, I believe, people who participated,
Yes.
and you took down
The bulk of
the voir dire in the first week of trial,
the voir dire and the first 2 weeks of evidence.
and the other 7 ladies who have now gotten all their material done and are waiting for your
Correct.
section.
Yes.
Now, I'm told that you had promised that you could deliver 15 volumes, 3 sets of 15 volumes in February. You did not deliver any of those
I
volumes.
did not. I did not, Your Honor.
Okay. How many volumes are you completed with at this point?
I'm about halfway. I had to stop working on it temporarily. I had some mental issues going on and physical as well. So much so,
Could you speak up a little bit, Ms. Six? I'm sorry.
I'm nervous and I apologize that we even have to be here. So just my body shut down and I just could not function. Depression just set in and I was just out of there. So I'm addressing that. I do have help, Scopus helping me through and proofreaders. I am confident if given a 1-week continuance, I'll have all the 45 volumes and
How long did you say?
I have 45 dates. So 2.5 times what the others had. I've had carpal tunnel surgeries on both hands before and trigger finger release in 18. I now have a trigger finger in my thumb. So it's been getting stuck and I can't do much. And so then I have to rest, intermittently. I went to the doctor last week. I got a cortisone injection. It's helped some. I am scheduled for surgery on the 31st to address that. But I definitely am confident I can get the volumes completed next week. Then I can focus on my surgery and healing.
Did
and
you
moving
use a recording device for your part of the record that you were taking down?
Some of it, not
How
all.
much of it?
Some days I did, some days I didn't, because it was kind of slow. It just depended on what was going on. It was jury selection, individual, one at a time, so it was kind of slow. It wasn't, and the defendant was pro se.
How could you possibly do in a week what you haven't done in a couple of years?
Well, I mean, I hadn't started it prior to.
Right, why not?
Because I just hadn't, Your Honor. I just hadn't, and we didn't know when it would be due for sure. I mean, I know it would, I just hadn't started. I know they can cancel it.
You didn't know when it would be due. Why wouldn't you know when it would be due?
Well, a reporter's husband passed, and she was putting in extensions.
No, I mean, the original due date was a set time, right?
It was,
And you
but I
didn't
was,
work on it until then? You didn't work on it before that point? Did you?
no, I did
Right.
not, Your Honor.
Okay.
Have you filed records and appeals in the past? I mean, I don't mean that, I just
No, I
don't
know,
know you.
I understand.
You've never, you have or you have?
I
Have
have.
not.
I have several
So
times,
you're familiar with the process?
very much so now.
You had some issues with Austin Board of Appeals.
Yeah, last year.
They fined you for not preparing records.
Yeah, these last 2 years has just been,
And you mentioned you had some
downfall.
scopers that were helping you?
I have,
Can you identify who they are?
one's name is JT Parrish.
Just, that's one?
And
I mean,
myself.
I hope you don't, I mean, forgive me if this comes across the wrong way, but I have a hard time believing that you could finish this in 1 week. I mean, I would love it if you could, but I mean, do you think that it's a good time for you to be potentially overstating your capabilities?
Not at all, no.
Right,
Because
so,
everything is riding on this.
yeah.
I have lost everything, Your Honor. Money, income, life, you name it. Everything.
Where would you be while doing this work? Would you be at home? Would you be at a courthouse?
I'm going to stay with my parents for the next week. They're in
And
Fort Worth.
Where is that?
They're in Fort Worth.
In Fort Worth. Do you have any care obligations towards your parents?
No, they're 80, you know, my dad will be 80 next week, and my mom is 81, and they're mobile and can do for themselves.
Well, you are probably familiar with some of the other techniques that courts, including this court, have used in the past
Yes.
under circumstances like that.
And I've been there, Your Honor. That was something last year as well. Like I say, it's just been a downward spiral, and now this is the last of it. And once this is off of my plate as far as being done and filed and submitted, then I can breathe.
Well, there's another thought here. We do not need a rushed, inaccurate transcript. That would produce
Right.
additional problems
Right.
for the litigants and for the court. We need accurate materials put together in a record, and we're trying to think about how best to get there, given that we have a man who's on death row.
Yes.
And can't proceed, and he's he's more than a year overdue to get the record. So I'm just gonna think out loud of a couple of options. We could have you, in the past, we have had a court reporter in the basement of this building during the day with somebody, with the court reporter to supervise them, remove them from any distractions, and allow them to process a record. We could have a similar arrangement like that in Tarrant County with the Tarrant County judge up there. We could do that in Denton County or something that's convenient to you. And you're saying you think you could do that at home?
I won't be home. I'm just going to go to my parents where I know there's,
At your parents'
yes.
facility?
It's just the
Do
two
you-
of them at their house.
Are you as confident that you would be able to get that work done?
I am, Your Honor. I was an official, I've been an official in Hawaii. I've been an official here in Texas. So I'm familiar. I am a real-time writer.
But you understand, I think our reluctance.
I
this period
understand.
of time.
I don't want to go past, cutting you off, past the deadline of the March 17th of the entire record being filed. So with the week left, or not left, but if you were to grant me the week to the 12th, that would still give Ms. Young.
And you believe realistically you could get
Yes, yes.
You have, 45 volumes, I think, to prepare between today?
Well, not 45, but I mean, you know,
How many? No, yeah, how many?
I'm about halfway through, so
It's taking you how long to get
20-something.
halfway, but you're gonna be able to do it in the rest in a week?
Yeah, because I'm not doing nothing else. And
Ms.
I
Dixon,
have,
Of the 45 total that is due, you believe perhaps at this moment, as you stand here, you've done perhaps 22 or 23?
yeah, something like that,
We
yeah.
have 22 or 23 left of a quality that you could hand them off to us.
Yes.
You think you could do those by March 23rd?
March 12th,
March
next Wednesday.
12th of 2010?
Can I-
And your parents' home?
Let me just interject. I'm really concerned right now. Judge Newell sort of hinted at it because it's taking you however, months, years to get halfway through, and you're basically saying you can get the next half done in a few days. This is not a normal circumstance to have court reporters that we have to bring.
I
know,
understand.
just hang on.
Sorry.
This is really unusual to do this. It's really unusual to do this with all these people here, but it's really unusual to do this, okay? And when my concern for you right now as a human being is that I don't want us to have to do something even more unusual if you don't turn this in. So when you say March 12th, like, just take a deep breath and please understand that if you say March 12th and it's March 12th and we're all up here and there's no record, like, that's gonna be bad. So just take a moment and just think, if you really think March 12th is the day, that's fine, but I mean, just understand that this is a really unusual circumstance, and it will get even more unusual in a very unpleasant way if you say March 12th and it doesn't happen. So just be careful about, I know you say you had surgery on March 31st. The deadline for all this is March 17th, but just be careful saying that, because it's not gonna be good if March 12th comes along and it's not here.
What is your parents' address?
I understand. 504 Asher Court,
Spell that, please.
ASHER Court, Fort Worth. Their zip escapes me. That's like Blue Mountain, Fort Worth.
It's like
Do you know the
Alliance.
zip code?
No, Alliance area. I don't know the zip code. But I'm confident.
Do we have any further questions?
I don't.
All right. Ms. Dixon, what's going to happen right now is we are going to convene very briefly. We'll discuss the options that we see, and we will come back, if you will stay here, please.
Yes.
We'll come back and tell you what our decision is, and we look forward to getting that record complete one way or another.
Did you
Let's
need
take a
any
break for-
documents from the doctor or anything? No,
Did you bring documents from a doctor?
I did, from my surgeon, yes. I have it.
You can give those to our clerk, who is here.
All rise.
seated. All right, yeah, please stand up. All right, Ms. Dixon, the court has made a decision. The court finds that you are presently in contempt. We have heard from you that you have half of the 45 volumes prepared at this point, and that you are prepared to complete them by, I believe it was March 12th. You had earlier indicated that you could complete them over a period of 3 weeks. We are going to give you the full, or close to the full period of 3 weeks, notwithstanding that you have already completed half to finish. So want you to take just not just March 12th, but to go to March 25th. Focus on doing only this transcript, the volumes that are due, and accurately and completely. We're also scheduling a show cause hearing for March 26th that may or may not be necessary. And if we have that show cause hearing, it may involve your confinement along with somebody to supervise your completion of that record and fines. But at this time, we're not doing that. So we're expecting and hoping that on the 25th or before, you will deliver those volumes you've been working on to Betty Young. Do you understand?
Yes, Your Honor, thank you.
That is the order of this court.
Yes, Your Honor, thank you.
Okay.
Thank you. Yeah, excuse.
Thank you.
Thank you.
She asked if she could be excused. Sorry? She asked if she could be excused.
You can be excused. I'm
Thank
sorry.
you.
Sorry. Sorry, I couldn't hear you. Court will now hear PD 076024, Ray Lee Cockrell versus the State of Texas. Counsel, could you please state your name for the record?
Good morning. I'm State Prosecuting Attorney Stacey Soule. This is a really interesting case about the intersection of two, one odd, one very typical statute that this court deals with. And talking about injury to a child, this is a statute that really brings home how society protects its most vulnerable, because it protects children, elderly, and disabled people, and provides for certain omission offenses with that. And here we have the duty to restrain a dangerous dog from the Texas Health and Safety Code. So all these combine to bring home the issue of, does Texas Health and Safety Code 822.042A, the duty that belongs to a dangerous dog owner, provide a basis for injury to a child by omission under 2204? And there's two ways that omissions under 2204 can happen. One is if there's a statutory duty, and the other is if there is care, custody, or control. Mechanically, for the importation of the duty coming from outside of the penal code, there's two ways mechanically that it can come in. Through 1.03, which provides that Titles 1, 2, and 3 of the penal code apply to offenses outside of the penal code.
Counsel?
Yes.
What makes it a duty? I'm not just saying that so I can say the word duty. Like, what makes it a duty? Is it an offense? Is it something that says you shall do something? How do we know? How do we look? I mean, I guess the thing that you're gonna get probably is a lot of questions about, there's so many of these duties out there.
Mm-hmm.
How do you find some way of reining some of those things in? Is it just an offense? Is it some sort of statutory duty? How do we know? How do we make that determination?
Okay. So the plain language, at least of 2204, does not state that it has to be assigned as a duty itself. And so it's 822.042 is titled Requirements of a Dangerous Dog Owner, and imposes upon a dog owner to restrain or enclose a dangerous dog. It's a shall. So that, to me, imposes a duty that a person is supposed to take care of that. And also 822.005 also treats it as a duty.
Sure. Well, I guess the thing I would sort of ask about that is, what about something like maintaining a single marked lane?
And I
That's
think
written kind of the same way.
And I think that there's a difference between, and it's certainly recognized more in civil law, of something that's an affirmative requirement versus a conditional duty. And in the civil sphere, the Supreme Court has looked at traffic offenses and described many of them as being conditional, like failure to yield, because it really depends on the circumstances at the time.
Okay.
And then the question is ultimately wrapped up into a jury question of, was this reasonable? And so I don't think a conditional duty like that can supply it for.
So where's the text that says conditional duties are not the same as duties?
I understand what you're saying. The other, sort of aspect of traffic offenses is that most of them are negligence.
Yeah.
And the legislature has, in 1989, it was an offense for omissions to be done negligently, and they removed that in 1989. So that, in and of itself is a limitation on that.
So counsel, let me ask you, I'm going to assume that there's some sort of regulation, let's say, on storing dangerous chemicals or things like that. So I don't store my dangerous chemicals well, whatever, I spill a barrel and the gas escapes and some kid, has a horrible asthma attack, has to go to the hospital, spends a week in ICU. Is there a limiting principle? Can I just scour? If I'm an enterprising prosecutor, do I get to scour every black book in my office that I don't ever read? To find a duty and go, aha, I found a duty that they have violated and it caused these injuries. What's the limiting principle?
I have a great limiting principle for you.
Okay.
Okay. So, and this is where I'm going to point to Texas Supreme Court precedent of Perry versus SN. In that case, there's a backstory to this, which many members of this court are going to be familiar with. Involved a negligence per se case, and even though negligence is not on the table here, I think the framework of how they analyzed this was very helpful and relevant in really trying to cabin what things are going to supply a duty. So in Perry versus SN, it involved the Kellers, Dan and Fran Keller, who were an Austin couple accused of molesting children and abusing children sexually. And I want to just make very clear that they have been exonerated in 2017, but this case arose out of those facts in which they had family friends over who supposedly witnessed the abuse, or had maybe heard secondhand that there was child sexual abuse going on. And so the parents of the children filed against, for tort liability for per se negligence against the three people for failure to report child abuse. Okay, so that's something that we are all familiar with, that duty, for sure. And so the court set out a test on, are we going to recognize this statutory duty, even though it's not a common law one? What parameters are we going to put in place for this? And it's really a two-part question of, does the victim belong to the class of individuals who are meant to be protected from this? And it's kind of like, is this a primary purpose of protecting individuals? And the court said at least all the children in the daycare fell within that class. So it wasn't even just the children that had supposedly been part of the lawsuit. The second question is the injury the type that the statute was intended to prevent? And looking at that, Does it cause liability without fault? Does it capture too many collateral people into it? And one of the things in talking about whether it was so collateral, was talking about a person having cause to believe that there's child abuse, that's really the triggering mechanism to report abuse. And having cause would certainly bring in probably way too many people, because it's not probable cause. It's too loose of a standard. And so the court did not impose a negligence per se in that case. And I think that this is certainly a standard that can be applied here, but I also think the standard very clearly is played out in 822.005, which makes it an offense already. The legislature has already made this causal connection for us in 822.005 for when there is the failure to comply with this duty and there's injury. And so here we're just notching it up one for this certain protected class of individuals. Judge, it looked like you had something to say.
Yeah, well, I was just
so
gonna
didn't-
say, like, tort law and everything is a lot more baggy than sort of statutory principles. And I mean, to some extent, you're looking at this text of the statute, and on the one hand, I see exactly what you're saying when you're talking about when it comes to dangerous dog duty, but it does seem like that opens the door to things like rules of the road, lead pencils or something, designed to protect children, no lead in your pencil.
Again, I don't think rules of the road would necessarily satisfy the test, and for the same reasons that have been pointed out.
Well, it wouldn't satisfy the negligence per se test, but that's my point, is that the negligence per se test wouldn't be part of the text. That's not referenced in the text, is it? I mean, we don't have this negligence per se limitation based on the statutes we're looking
Well,
at.
that's like part of their body of law.
Okay.
Okay, that is not statutorily, this test is not
I got it. Okay.
statutorily based. And so we come up with tests all the time to determine where we draw in the lines. And so I don't see any difference here. I want to be true to what Chief Justice Blacklock talked about at the State of the Judiciary address about taking the legislature at its word, and it says statutory duty. It does not say a familial duty, which is what the court.
Right.
But I absolutely see your concern of we don't want to sweep everything in. And I think that this is certainly a limiting principle. I think in this case, in particular, looking at 822.005, having the legislature having already made that connection for us.
But why wouldn't we say, if we're gonna draw a line, that they made that connection and said, just use that statute?
There's not an
Only third degree.
but there's not an impera materia claim here, number one.
Okay.
Number two, it also allows for prosecution under a different offense. So yes, they could have used that statute, but we do have a protected class of persons to the point where this mental state for injury to a child, you don't have to prove that the person knew the child's age. And so it dispenses with that. And there's also, just by the mere fact that it's the offense, you have the mental state that limits it as well. It still has to meet the elements for injury to a child.
Can I ask you a question? I'm just trying to get my brain around this. On 2204 subsection B, you got two options here, 1 and 2. Number 2 says on the omission, the actor has assumed care, custody, or control of a child, elderly individual, or disabled individual. The injury must occur to that specific child, elderly individual, or disabled individual that the actor has assumed care, custody, or control of, right?
Yes.
Okay, so now let's go up one. The actor has a legal or statutory duty to act. Why would we not also say the actor has a legal or statutory duty to act with respect to the child, elderly individual, or disabled individual who was injured? Here, you seem to be implying that actor has a legal or statutory duty to act with respect to the entirety of all children in the world, or with respect to the entirety of a public duty to all people. Why do we restrict it under number 2 to just the child, elderly individual, or disabled individual that the actor assumed care, custody, and control over, but you want to expand number 1 to say the actor has a legal or statutory duty to anyone, and therefore we impose liability for this damage to anyone?
Number 1, I don't think it's in the plain language to attach it to a particular individual for that portion of the statute. taking the legislature at what they said, they obviously know how to distinguish between directing it towards the person who's in care, custody, and control versus a larger body that may be protected by a statutory duty. And a statutory duty doesn't mean that everything in the world is at issue. But you certainly can, there's an aspect of foreseeability here, which I think really drives this whole legislation in place, is that when you know that you have a dangerous dog that has attacked people before, there's a foreseeability if out in the public, it is going to do the same thing again.
I couldn't agree more. But I was going to ask you this in light of what you're saying here, is that in the end, doesn't your argument end up sort of devolving into, you know what? We're going to be stuck with the plain text. We're not really here to determine if there's a limiting principle because the legislature hasn't provided us one. And if the legislature wants to write this broad statute, then we give them what they want. But then when you said that, that's what I thought. But then when you say, but there's a foreseeability aspect to it, I don't see that anywhere.
But
I don't see that in any of the requirements.
There's always been, this court said in Sear, talking about mental state for injury to a child, that it is intertwined.
Okay.
So there is already a foreseeability aspect. I think Judge Cochran talked about it in one of her opinions years ago in great detail. Actually, I think it was Rodriguez with, Williams with the child and the candle and the foreseeability. Okay, so there are limitations there, but it's not, I don't think it's.
I guess that was tweaked on the idea of recklessness. That's like the foreseeability ends up being tweaked into the idea of recklessness.
Is.
Gotcha.
And the mental state here isn't at issue, but as I presented in my brief and as the dissent pointed out below, there may be an issue. So I just want to say that that's not on the table now, but that may be something that for remand, depending on where this court falls on that.
Well, I'm curious about the duty, that is on the table here, right?
Yes, it is.
And I'm wondering whether, or can you maybe address how the designation of dangerous dog, and whether that has, I can't remember if it has any notification requirements or whatever, but how does that intersect with our determination of the existence of a duty?
Okay. It can happen through notification.
Yeah.
Here, it was based on the prior acts that the defendant was aware of, having previously attacked people and caused injury. And so once a person has that knowledge, that is when the duty sets in place.
So there's no external proceeding required to acquire the designation of dangerousness?
No. It's, the onus is put on the animal owner who has the dangerous animal.
Counsel, help me understand this.
Yes.
Under 2204, if you take an overt act, if you act and cause injury to a child, elderly individual, or disabled individual, you are liable, right? My understanding when they included the omission part was if you have a duty to a child, elderly individual, or disabled individual, or a specifically defined group of same, and you fail to act, you could be held liable for the omission. But as I understand the addition here on subsection B, it was specifically designed to say you could be liable for injury to a child by omission if you have a duty to protect, to care for, to feed, to shelter, to nurture, to protect a specific elderly individual, child, or defined group of same. But you would not be held liable for omission to the totality of all children or the totality of all individuals. And that seems to me exactly what this is designed to do. And the state's position here seems to undo that completely and say if you have any duty that you might be held criminally sanctionable for, no matter how minor, Class C misdemeanor here, and you fail to do that duty to its fullest, execute that duty, you can be held criminally liable to the tune of 99 years if any injury to anyone results by any path. As to, you come back and say, well, we'll protect it a little bit with foreseeability, but it seems to me, and I want, that's why I'm asking you to clarify, it seems to me the state is stretching this deliberately 180 degrees to what it was designed to do. I acknowledge affirmative action, injury to a child or elderly individual, liability, criminal. But Here, the omission part, criminal liability for omitting to discharge a duty, seems specifically by the legislature to be intended to limit that duty to a child or group of children, a elderly individual or group of individual, who the actor, or in this case, the person who omitted to act, has a either statutorily defined duty under the family code or has assumed responsibility as a caregiver, nurse, teacher. Clarify that for me.
So in 1989, as far as where the care, custody, and control aspect came into play, there were several cases in Texas where it was a son not caring for a mother, a babysitter not caring for a child at the time. And so then developed this duty of care, custody, and control, because it's something that's within that person's control. This is analogous. These dogs are within the control of the owner. The owner has a care,
But the
custody.
child is not within the control of the owner of the dogs. The owner of the dogs is not the babysitter of the child or the caregiver of the child or the teacher of the child. The owner of the dogs didn't even know the child was in the woods.
I think we have time for rebuttal.
Thank you.
May it please the court. Counsel, my name is Troy Hornsby. I am a private attorney appointed to represent Mr. COCKRELL in this case from Bowie County. It came out of Texarkana through Bowie County and the 6th Court of Appeals. I did not represent him at trial. I did not represent him on appeal, so I apologize. I'm getting to the game a little late. This presents a very interesting question, and the question is, what duties legally work to support injury by omission to a child? That's a very interesting question. And when the court granted review on that, I don't question that because I think it's an incredibly interesting question.
Counsel, before you get to that.
Sir?
Let me ask you some questions about where we are before we get to that.
Yes, sir.
Okay, so, and I'm looking at the state's, the prosecuting attorney's bench exhibits. And they start out with the injury to a child statute. But then, a couple of pages over, there's the attack by dog statute. The attack by dog statute, if they charge under this, then this offense would be third-degree felony, correct? Is that the way you'd say that the most, if they're just looking at attack by dog statute?
No, I don't think it's an offense. I don't think it's a criminal offense. 822.024 is not a criminal offense. In and of itself, you can look to other provisions to make it a criminal offense.
Yeah, or two.
Okay, thank you.
So having said, we're here to address this most interesting issue. What would I like you to do? I'd like you to sidestep that issue. I'd like you to firmly, quickly, and I'm giving you that out. Let's take a look. What's that out? 822.042 is not a duty. It is not discrete. It is not specific. It is not clear. It is not a duty. Well, why not? Why would I say that? It's an alternative or conditional duty. Clearly. Look at Section A. Section A tells you what you do if you got a dangerous dog. Well, you got to register that dangerous dog. You got to get some insurance. You've got to restrain that dog within 30 days. Or deliver the dog to dog control, to animal control. You have an alternative duty. You can pick which one you do. Now, if you have not alleged that I failed to deliver the dog within 30 days to animal control, how can you say I violated the first section of duties? It's a conditional or alternative duty. And an alternative or conditional duty cannot be the basis of an injury by omission to a child. Why? Because it's not imposed under the law. It is not imposed. There is no duty that says you must do these. Because you can do either. It's a fork in the road. When you come to that fork, you can take A or you can take B.
But what if you don't do either one?
Well, then you're in violation of both.
Right.
So does every dog get a 30-day bite, all the bites you can do?
Under that statute. Under that statute. Yes, sir.
Dogs maul children for 30 days.
It's the purge. It's the purge for dogs, is what you're saying.
Well, there are other duties. There's a common law duty to prevent that, and that could certainly.
But that common law duty is strictly civil, right? The one bite rule.
Yes,
You own a dog, the first bite, you're not civilly liable. After one bite, you can be civilly liable.
Yes.
It doesn't extend to wild animals. If you hold a wild animal, we hold you strictly liable. You're civilly liable on the first bite unless you're a zoo. But here, we're talking about criminal liability, not
Correct.
civil liability.
Absolutely, you're absolutely correct. And that duty is not implicated here. It's not implicated in any way. It's not at issue. Is that a better duty to be here arguing about? Probably.
How do we sidestep? Let's go down that.
Sidestep.
Because your guy didn't do either, right?
You do exactly what the Court of Appeals did. The Court of Appeals said, this duty is not unconditional, clear, and specific. It's an alternative, conditional duty. Ergo, it does not form the basis of injury by omission to a child because the law has not unconditionally imposed that upon anybody.
But it has unconditionally imposed that the defendant do one of those things.
It's imposed a choice.
I'm sorry, I missed it.
In other words, you have to do, the law requires that one of those three things be performed, and that's a duty, isn't it?
Absolutely.
Okay.
Yes, but you've taken a statute which has duty A, duty B, duty C, and we're saying we're going to get you under A, here, under A, no, under A1, no, A2, we're going to get you under A2. One micro condition, one small duty under multiple duties, which by the way is alternative, because you don't have to do A, you can do B.
If you fail to do all of those things, any of those things, then haven't you failed to comply with that duty? And after all, what are these three choices designed to prevent?
Injury to a child. I'm sorry, injury.
What is exactly. What is the sanction for violating? Assume a dog owner gets notice he has a dangerous dog.
Yes.
Assume he does not elect to perform one of these four remedies under 8204-2A. What's the sanction?
None.
Because he might have also surrendered the dog.
Bingo.
Okay, assuming he doesn't do any of
But
them,
he didn't.
what's the sanction?
Well, we don't know that. That was not alleged, that was not proved, and that was not in the jury charge. That's the whole point. That was never at issue in this thing.
But if, assuming he doesn't elect to do any of those, what's the sanction?
Under that statute.
Under this, 82204-2A.
Nothing under that. It's a procedural way to grab the dog, to destroy the dog, to...
And 82204-2A is the source of the duty effectively being alleged here, right?
Yes, sir.
Okay, so if a duty that has no sanction, either civil or criminal, can form the basis of an omission for an injury to a child, where's the limit? What duty can't form the basis of an omission for injury to a child?
Gotcha. Now I understand your question. We're switching gears a little. I gotcha. Okay, what can we do? Well, we can look at what the legislature said, and the legislature said basically any duty. That's what the state has argued repeatedly. I agree with the state. They're right. That's ridiculously broad.
It has a potential criminal sanction.
I'm sorry?
Doesn't have to be a duty that has a potential criminal sanction.
That's what the statute
Under the
says.
state's theory, any duty imposed by a statute is sufficient.
That's the way that statute could be read, but that won't work. How do we know that won't work?
Is our job to make it work, or is our job to just say what they said?
Well, it's a good question. That's a good question. You're supposed to say what they said, but there's a caveat. Under the vagueness doctrine, you're supposed to interpret the statute in a way which makes it not vague. That's our limiting factor. So we got two limiting factors here. We're going to look at. This is all we have to look at.
Has the vagueness constitutional challenge been raised here?
I have a non-vague way to read this statute.
The vagueness constitutional challenge, is that in front of us?
Yes, sir. I have raised that, absolutely. And I filed that form, absolutely. And I think it's strongly presented. You have two guiding rules here. You have what the legislature told you, and we have the vagueness statute. Those are our guidelines. So let's take a look at those and let's make this work. How do we make that work? Okay, I'll tell you how to make it work. The way to make it work is not Perry versus S&M. That's a civil statute. We've got to look at multiple factors to determine whether or not the duty can be imposed, right? Well, that's incredibly messy. That's the opposite of the vagueness challenge, right? The vagueness challenge is, hey, let's look at the statute, so let's look at what it says, and let's determine what...
Let me stop right there. So, I mean, it sounds like what you want is to get in your magic time machine and go back to the trial court and then file a pretrial writ to say that this is unconstitutionally vague. So what do you say to that?
I can't do that.
Well, I know you can't. But I mean, it feels like that's what you want to do.
Fair enough, you're right. So what's my argument? My argument is I came to you and I said, hey, I've been appointed and I just got thrown in the middle of this deal here at this court. I wasn't involved at the trial, I was not involved at the Court of Appeals, and now I stand before you and I say, hey, this is vagueness, and you say, it's too late. Is it? The state raised the argument. Here's the way we need to interpret this statute, right? You didn't even grant their petition, you granted your own petition. Let's say, let's take a look at this thing. Let's figure out, how do we interpret this to make it work? Well, if you're going to interpret it to make it work, you've got to interpret it in a way to avoid vagueness. It doesn't have to be a challenge from the trial court level. That's still your duty. That's what you have to do now regardless, right? I'm trying to help you. I'm trying to say, I got your way out. Here's your way out, okay?
Why do we need a way out?
Well, it's got to be addressed. I think the way out. I agree. I think
Why
the way
is
out.
it, well, that's, no, to build on that point, why isn't the answer to be like, yeah, this statute's kind of broad, legislature, maybe you should do something about it? Why isn't that our way out?
Well, it can be, but again, you've got a duty to interpret the statute in a way that avoids
Can you
vagueness.
give me an example of a duty that's not conditional that you could say would satisfy that?
I'm sorry, say that again. A duty.
A statute that creates a duty that's not conditional. You're sort of looking at this as, you're saying that the requirement is the owner of a dangerous dog. That duty is not the kind of duty that should apply in this circumstance because it's conditional. Can you give me an example of a statute that creates a duty that's not like that, that would be outside the penal code, that could be brought in this circumstance?
Well, I think the example was chemicals. You don't contain chemicals in a way and some child is injured. I don't know a specific statute, but
Okay.
something that was unconditional, specific, that said, hey, you can't have chemicals, you've got to keep them contained, and something very specific, that'd be fine. That would meet that.
What if the statute says, contain the chemicals, restrain the chemicals, or turn them in? Right.
Well, okay, you're right. There's problems with all of it. I agree with you.
Yeah.
I agree with you. I think your answer lies in your beginning. And here's what I mean. This court addressed this issue in, oh gosh, I can't think of the name of this case.
Neither could I.
Billingsley, 1989. Court interpreted this, and what did the court say? The court looked at a very similar wording on the statute and said the omission must be criminally based. That is, it must be a criminal offense or criminal liability imposed for the omission.
And it's undisputed here that that's not the case with this dude.
Oh, no, I'm not. I'm going back to the interpretation of where they got. Yes, I'm sorry. So, what did this court do? It said that's the interpretation. That's what we're saying the interpretation is. Why? That was not exactly in the wording at that time either, was it? So why? Why did y'all use that language? Because it met the vagueness standard. That's why. How do we know? How do we know? Okay, we all know what vagueness is, right? We say, all right, you can't have a statute where you're referencing stuff to come in all over and you can't figure out what the heck the statute says, right? That's vagueness. You can do it by reference to maybe a single statute or that sort of thing, but beyond that, it starts to become troublesome. What's the broadest thing that we can think of where vagueness is not challenged, where it's not a problem, where it's met constitutional muster? The felony murder rule. Felony murder rule has met U.S. constitutional review with regard to a vagueness challenge. So you're taking a felony murder and you're saying, well, you can reference felonies and bring them in. So what do we know? That's our blue sky. That's our safe zone. That's our protected area. We can do that without challenge, and that's what this court did in Billingsley.
Well, you're saying, I'm interested that you're saying the thing about felony murder because this argument that the state is making seems analogous to what we decided was okay in Lomax, which is a felony DWI that results in a death because of felony murder can be brought as a felony murder, even though there's a specific voluntary or intoxication manslaughter that has a much more limited penalty. Why is it that we can't do the same thing here? Why isn't this this appropriate in this circumstance?
Well, I'm sorry, I'm not exactly
So
following.
like basically in the felony murder case, the felony murder with the felony DWI, you've committed a felony DWI, and you also caused a death, and if you allege it as felony murder, then you now have a full murder charge, and it goes beyond the limitation of the punishment that you would have for intoxication manslaughter, which is driving drunk, and you commit a murder, or you kill someone. Well, this seems very analogous to that in that there's a specific statute with regard to maintaining a dangerous dog.
Yeah.
Right? And that creates this sort of inciting event or this one sort of precondition. But if you do that and it results in injury to a child, why can't you then use injury to a child as a way of saying this is attacking or this is designed to protect a specific protected class, and therefore it's fine if we want to raise it under the injury to a child?
I see what you're saying, but this
And
this
if the felony
statute,
murder statute works, I don't see why that's any different than the felony murder statute.
well, as I see it, 822.042 isn't even a criminal offense. And that was a conclusion of the Court of Appeals and thought that was important. I think it's important.
But what about the 05, right?
It's a different provision.
Right.
It's a specifically different provision, which was not addressed, was not indicted.
But there's all kinds of other provisions that can be factually implicated in any kind of a criminal charge. We have codes governing physicians. Clean the instruments
Yeah.
after you perform a
Yes.
procedure on someone who has Ebola.
Yes.
Okay. Don't use them to serve food in the cafeteria at the hospital because it's cheaper.
Right.
Right? Those are separate statutes. You could make the same vagueness argument all over the place. The only difference here, it seems to me, is omission. And what's special about the omission when the statute, the penal code itself, invites you to go look at other sources of duty?
Well, if you're asking me, did they allow that? Are they authorizing that the
I don't
statute?
think there's a question, right? I mean, the penal code says, on its face, other sources of statutory duty.
Yes, I agree with you. That's what it says.
And for,
I don't disagree.
For negligence, recklessness, or intentional acts, you can have lots of statutes that make it, that prohibit the conduct that the person's engaged in, that could be the mechanism by which the injury is sustained in a just routine criminal case.
I absolutely
Why is that
agree.
vagueness?
Well, why is that vagueness? It's massive. It's as massive as it could possibly be. So vagueness says, well, you can't, it has to be leveled out in the statute in a way that the average man can read it, average man, not attorney, read it and say, yeah, I can see that this is an offense, or I can see what's not an offense. So what duties can we impose here? Federal law, state law, common law, statutory law, ordinances? It doesn't exclude anything. It doesn't.
So now I think I understand what you're saying. So this is sort of like your argument is essentially sort of like, this is an impermissible umbrella type offense. The way they're using it would be like that. Like, say, engaging in organized criminal activity lists these specific things, but you're limited to that, and that's the way you do an umbrella type crime. Felony murder is the same way.
Yeah.
But you're saying that because this doesn't put, this umbrella is too big, or because it's just too broad, that basically any conduct would become criminal.
If it was interpreted that way, yes. That it-
Address the mens rea element. Going back to the felony murder example. In the felony murder context, you have a specific intent to commit a felony. You have a mens rea of an evil act to commit a felony, and you are held liable for any other evil acts that occur. A reasonable defendant in that position could understand, if I'm engaging in an evil act and I'm committing a felony, I could be held liable for these other felonies, murder. In this context, you have, using the paint or chemical example, a homeowner who doesn't lock his paint up. It isn't in his mind, because he's not engaged in a criminal act, he's not engaged in a felony, there's no mens rea about causing an evil act. It isn't in his mind that by failing to lock up his chemicals, he may end up being liable for 99 years on a felony injury to a child. Identify or address the distinction.
You're absolutely correct. And that distinction has been addressed by the Supreme Court of the United States when it's talking about vagueness challenges. And it said, we're looking at the vagueness issue here, and we're sort of stepping off of it for one reason. We're stepping off of it because this is an intentional crime. And what do we have here? We have a much broader statute. The statute says it can be, and I'm looking for it, I'm sorry.
Reckless, knowing, intentional.
Intentional, knowingly, reckless, or with negligence. So it's a much broader, a lesser requirement or a broader area that can be covered. And so when you have that factor, that leans in favor of finding vagueness, finding that the statute is too vague. That's a consideration when you make a vagueness challenge, is the intentional act. And so if this was merely an intentional act and I was making this challenge, you could say, well, I don't think that applies. That doesn't matter because we're talking about intentional acts. But here we can be talking about.
From your position, if I accept the state's argument, from your position, what are the limits of what this duty can be to trigger felony liability for injury to a child?
This court has to determine those. I can't tell you what it is, but I can tell you that the blue sky or the safe harbor is to say it has to be a criminal statute or a duty which the omission violation of makes a criminal offense, just like this court did originally in Billingsley.
It's undisputed that's not the case here.
Yeah, I'm sorry, yes. No, but I'm just saying that that standard, that interpretation worked then. Why can't that standard or interpretation work now? That's my argument. So to sum up, I'd sure like you to sidestep this. Step one, say, hey, that's not an unconditional or specific or clear duty as the Court of Appeals found. And so we don't really have to get to issue 2. But if you disagree and say, no, we've got to get to condition, we got to get to item 2, well, then this court has to interpret it. And that's a tall order. And I'm sorry, I can't provide you any guidelines because I think you have 2 guidelines and only 2 guidelines. You got the statute and you got vagueness. And there's a whole lot of air in between. The only thing I can offer you is your prior solution. And your prior solution, Billingsley, was to say it had to be a criminal offense. And a criminal offense could form the basis of the omission. But that's it. I appreciate the court's time.
Thank you very much, Gerard.
And there's nothing contradictory in my view about this as far as whether there's anything vague or conditional. And I don't think.
I'm glad you mentioned conditional, because earlier you said,
Yes.
when I asked you about rules of the road, you said rules of the road wouldn't apply because that's a conditional duty. Well, now we have an argument that this statute that is being used is a conditional duty. Is it a
The
conditional
argument
duty?
is apparently that the statute gives the person who has knowledge a 30-day reprieve in which anything can happen with the dangerous dogs. And that's not the case. As Judge Erie inquired about earlier, that duty is effective upon learning that you do have a dangerous dog, that you learn that the dog has attacked somebody else. So that duty to restrain and enclose is immediate from that point on. Whether you turn the dog over doesn't matter. Then you don't have to restrain them anymore if you turn them over, but that does not in any way undermine or negate the duty.
Okay.
Counsel, what would you say if I went on a rant and said that this statute is liable? Is it just another example, like this prosecution, and I mean, I know nothing about this prosecution, but let's just say somebody were to say, this prosecution is just another example of the over-criminalization of the American criminal justice system, and we're taking misdemeanors and turning them into felonies, and we're reaching every code, we're going into the water section of the Texas laws to say that you didn't build a dam on your property and the water came out and some kid drowned. Like, what's the limiting principle? I asked you this the first time, but I'm looking for a limiting principle here. Give me one.
So back to the test of, is this what the statute is designed to protect? Is this the kind of injury? Is this the kind of person?
And
I think the legislature here has made it absolutely clear through 822.005 that this is exactly the kind of thing that it's meant to protect, and just carrying it over into injury to a child is just recognizing the fact that this child has a special status under our law. And as far as any policy argument that it's going too far and the state's trying to criminalize everything, I mean, that is something that is left to the people over there.
Right, but let's say you had some sort of weird ag code statute that said something about restraining water on your property, and all indications from the plain text, and if you wanted to look at hearings, this is about, soil erosion. But let's say a disabled kid, because the water wasn't restrained, drowned. I mean, are you saying at that point the state couldn't prosecute you under this section, even though?
I don't think it would satisfy it.
Okay.
And I think that certainly in writing this opinion, this court doesn't do advisory opinions, so I don't think it's wise to explain the statute here by what it doesn't entail elsewhere. But I think it is enough here for the court to draw the line, as the legislature did, by pointing to 822.005 and pointing to that and saying the legislature has already made this connection for us, the causation, plus the fact that you still have to meet the requirements for injury to a child, which come with a mental state. There are limiting principles available here that would stop it from reaching too far until the next case comes up.
Counsel, I know you're out of time. Excuse me. I want to ask one question. Same exact theoretical facts, this case. But the homeowner stacks some 2x4s against a tree next to the fence. 2x4s fall over onto the fence. Out go the dogs, injury. Under the state's interpretation here, if I read it literally, you still are able to prosecute this man and put him in prison for up to 99 years.
Can you explain the
Sure.
stacking?
Okay. Exactly the same fact scenario you have here. Because right here, what you have is an individual has dangerous dogs, a large quantity of them. He's on notice that they are dangerous. He has an inadequate fence, though they are fenced. The dogs escape. They cause injury to a child he did not know was in the woods, right? Okay, so exact same fact pattern, but the homeowner stacks some 2x4s against a tree close to the fence. So you have additional evidence of negligence on this homeowner. 2x4s fall over on the fence, out go the dogs, the same injury occurs. Now you're in a situation with additional evidence, in addition to all the evidence you have in this case. But if I read the state's interpretation of this literally, and I go with you, the state is free to prosecute this man and put him in prison for up to 99 years in that scenario.
So you're defining this as additional negligence, which is not
I'm giving you the
available
exact same
for
pattern you got here.
omission, though.
Right, the exact same pattern you got here. Exact same facts you got here.
I'm confused, because I'm taking the statement that there's additional negligence on top of it.
Everything you have here
But
plus more.
you can't use negligence for an omission offense under injury to a child.
You can use recklessness, that's what you're doing here.
Thank you for a very fine
All right,
argument.
appreciate it.
We're well over red.
Actually, I did have one more question. Like, so in
one more
this,
question.
in this situation, the stacking argument, would that be similar to, say, the candle in the window?
Of
with recklessness?
foreseeability.
Foreseeability, would that be that?
I don't see how one has to do with the other. You're still on notice for the first part, and you didn't do adequate fencing. Thank you very much.
I'm fine with that. I'm finished. Keep on. Break on through the other side? Do you need a break?
No, I'm good. We're all good.
Okay, thank you. That case is taken under submission. We appreciate very much your exciting arguments. We will now hear ex parte AMARILLYZ ESTEVEZ, PD 058124 from Harris County. Please approach. And please state your name when you start your argument.
Thank you. Good afternoon. My name is Mark Bennett, and on behalf of the Institute for Advanced Criminal Law Studies, I represent AMARILLYZ ESTEVEZ. I want to talk about the rule of decision in this case. The rule of decision in this case is that the state cannot wire around a federal constitutional requirement with a state procedural law. Let me give you the absurd example. The state writes a law, in fact, the people pass a constitutional amendment that says that an indictment or information gives the trial court jurisdiction over the cause, but only if the judge is wearing a red bow tie. Ms. ESTEVEZ is accused of contempt, and she goes in for her hearing, and the state puts on its evidence, and Ms. ESTEVEZ's lawyer says, hold on a moment, Your Honor, I observe that you're not wearing a red bow tie. You violated the red bow tie requirement. And the judge says, that's fine, that's fine. I'll put on a red bow tie. I don't have one with me. We'll come back in 3 days or a week or so. Your client's going to sit in jail until then, but we can do that. We can follow the red bow tie law. Lawyer says, no, that's fine, Your Honor. We'll go forward today. The judge holds Ms. ESTEVEZ in contempt. Ms. ESTEVEZ, and this is a deviation from the facts in our current case, but imagine that Ms. ESTEVEZ then files an application for writ of habeas corpus, which is the only appeal, of course, from a contempt, there being no direct appeal. Ms. ESTEVEZ files an application for writ of habeas corpus, and eventually it makes its way to this court. This court says, what? This court says, well, Ms. ESTEVEZ says, my judgment was void because the judge wasn't wearing a red bow tie. And this court, I suspect, says, you waived that. You invited that error. Okay, so Ms. ESTEVEZ is still in jail. And now the state wants to prosecute Ms. ESTEVEZ for the DWI that was the alleged contempt. And now Ms. ESTEVEZ says, well, there's this contempt judgment against me, and it was with a red bow tie, but I waived that, and that should stop me from being prosecuted for the contempt. What does the court say then? The state knew about the lack of a red bow tie. They knew about that at the hearing because Ms. ESTEVEZ's lawyer at the time had objected. They didn't do anything to stop it. Did the state invite the error? It doesn't matter, though, because double jeopardy is a U.S. constitutional requirement, and the state can't wire around a U.S. constitutional requirement with a state procedural rule like a red bow tie, or like a written information, or a written indictment. The state has the burden here of showing that that judgment, the contempt judgment, didn't count as jeopardy. Ms. ESTEVEZ was clearly, from the record, you can look at clerk's record around pages 67 and 68, clearly the case was, at the very least, about her committing a DWI while on bond. There was no evidence of any other violation of the conditions of bond. The only reason the DWI while on bond was a violation of the conditions of bond was that it was a crime. The elements of the violation of bond were the same as the elements of the DWI.
I thought there were allegations of several other offenses during...
There was no evidence of that, yes. There was no evidence of any other
But there were allegations of, I believe,
yes,
8 other
absolutely.
offenses.
And that's a really interesting question, because now what happens when Ms. ESTEVEZ files a double jeopardy habeas in one of those cases? She's been acquitted of those because the state talked about them at the hearing, and there was no evidence of that. And no evidence is an acquittal. She has and Brian Garner says to pronounce it the American way. I don't know what the American way is, but autrefois acquit. Autrefois acquit.
That's American?
No, that's the French way, because I don't know what the American way is. Maybe you can tell me what the American way is, Judge Newell. Autrefois acquit. She's got a jeopardy bar, autrefois acquit. I've already been acquitted of these other allegations. If this hearing was about those as well, which the state says it was, I take them at their word. The Court of Appeals said that there was no evidence of the DWI because an information isn't evidence. And so Ms. ESTEVEZ has an autrefois acquit double jeopardy claim on the DWI as well.
How is the information that was submitted into evidence and not objected to not evidence?
I think it is evidence. I think it is evidence. I think it's legally insufficient evidence, but that claim hasn't been raised. It was the Court of Appeals that said that's not evidence, and they did that because that's what the state said in their brief in the Court of Appeals. I think that's a facetious argument, honestly. It was, the judicial notice was taken, and things that judicial notice is taken of are evidence. And the court took judicial notice, and it was a prosecutor who said that this thing had happened. It's evidence. It's not great evidence, but it's some
I have another
evidence.
question for you about your argument about the conditions of release. How is that not similar to what we do in a motion to revoke, where you have a number of things in your motion to revoke, which could include an offense as the basis for the revocation. Then you have the new charge, the DWI charge. So you have no double jeopardy issue. So isn't the real issue what happened, whether the contempt order was void or whether the court had jurisdiction after their power?
It's an excellent question, and first of all, the answer is that in the motion to adjudicate or the motion to revoke, the person is actually being punished for the underlying offense, not being punished for the new law violation. So you could revoke somebody's probation, preponderance of the evidence standard for the new DWI, and then prosecute her for the new DWI. And jeopardy wouldn't be implicated because the punishment on the motion to revoke was not for the new DWI. First of all. Second, the question of whether the judgment was void, according to this rule of decision, which is that the state can't wire around the double jeopardy claim, it has to have been void for some reason under the U.S. Constitution. And so it's the state's job here, it's their burden to show somehow that this judgment was void, not just under the Texas rules, which I think it probably was void under Texas's rules. Now,
But what was she punished for?
she was punished for DWI. So
No, she wasn't punished for DWI, she was punished for contempt, and that was the condition of her bond, is what I understand.
yes, but she's not punished for the new law violation. She's punished for the DWI, which is incorporated as a condition of bond.
Wouldn't that be true at every time there's a revocation? You know, we had you out on bond after
No.
armed robbery, and we said, don't commit any murders.
And
You committed a murder, and now we're gonna revoke you on your armed robbery.
no, because a revocation of bond doesn't trigger double jeopardy. Contempt, however, does. And I wanted to wait until rebuttal to talk about this.
Contempt does, what do you base that on?
DIXON.
I'm kind of curious.
DIXON. DIXON, which the state doesn't
Let me
even.
just interrupt you for a second.
Sorry?
I just find it unusual because I've never seen Bennett held in contempt picking up a new offense. Normally, the remedy is just revoke your bond.
Oh, right. No, it's a crazy procedure, and there are politics behind it.
Where does this happen?
This was Court 16 in Harris County, and it was happening for a while, and it's not happening anymore. It's not happening
You
anymore.
seem so relieved.
Seems like an unusual procedure.
I put a lot of work into making it not happen anymore, and I'm happy that I stopped it.
You mentioned DIXON, but DIXON was a very fractured opinion.
No, it wasn't. Not DIXON. Foster was a fractured opinion. The whole court agreed on Mr. Dixon's case, which is on all fours with AMARILLYZ's case. That is, the show cause said you violated your conditions of bond by committing a new law violation. And if you look at the underlying opinion in Dixon, the D.C. Court of Appeals opinion, which I've put in my notice of supplemental authority, if you look at the underlying opinion, it doesn't look like the show cause mentioned exactly how the bond was violated, just like this case. And what Justice Scalia held in Dixon, and what the whole court agreed with, nobody disagreed on Dixon. They disagreed on Foster. Foster is an entirely different case. They happened to be decided together. But in Dixon, the whole penal code was incorporated by the bail conditions, as it is here. And the violation of the penal code bail condition was treated by the U.S. Supreme Court in Dixon, and there's no authority to the contrary.
Here's my question.
Yes, sir.
The contempt proceeding is held by the court. The state really is not a party to that. And the court could circumvent the state's desire to prosecute somebody by simply holding them in contempt for picking up a new offense. And how do you explain that?
So there is a case in my materials in which, and I think it's the district court in Dixon, says, look, if the state didn't want this to happen, they could have just asked that it not happen, that we put off the contempt. The state did nothing of the sort here. They presented the evidence. And I want to get into why that's unseemly at best, but I'll let my colleague.
Just one question before you sit down.
Yes.
And so I'm trying to clear up some confusion. I'm seeing that there was an allegation that the defendant committed a crime and/or engaged in conduct resulting in his arrest. Is that same language also translated to the judgment for contempt in that same way? Is there a vagueness? Is there any question in your mind that the judge found that he committed a crime, or maybe that he might have, in the alternative, done something that might have made him subject to arrest for a potential criminal offense?
The only thing that there was any evidence of that might have subjected AMARILLYZ, she's a female, to arrest was the DWI. The information also alleged an open container violation. That's not an arrestable offense.
Whether you've committed acts that subject you to arrest is kind of a different factual inquiry than are you guilty of the crime?
Sure, I understand, and I think it's intended to be. I think it's written to be, we don't have to prove that you committed the crime. We just have to prove that you got yourself arrested.
You can see how that concerns me in light of the argument you're making about double jeopardy and.
Sure. Well, the court found that she had committed the DWI in the hearing. The court, so we don't have that issue in this case. The court didn't say, well, I don't find that you committed the DWI, but I do find that you engaged in some other conduct. But there really is no other conduct that could have resulted in her arrest. The elements of conduct that might have resulted in her arrest are, you committed DWI. Imagine if a witness had come in and testified, and the witness had said, well, I found her driving and she wasn't intoxicated, and I arrested her. Well, she wouldn't have committed engaged in conduct that could have resulted in her arrest. She was just driving. So it's only the fact that that the police thought she was engaged in something that was a crime that made her subject to arrest. I've deliberately split my time half and half because I want to hear what the state says when they try to meet their burden of showing that this judgment was void under the United States Constitution.
We're all looking forward to it. Thank you.
Thank you.
Spoiler alert.
Mr. Presiding Judge, may it please the court. John David Crump from the Harris County District Attorney's Office for the state of Texas, the respondent in this case.
First question out of the box. Is this a common practice in Harris County to hold people in contempt for picking up offenses while they're on bond? I've never heard of it in my entire career.
Judge Richardson, no, it's not. I can tell you that once my division got involved, in addition to Mr. Bennett getting involved, this stopped. And that's actually kind of the genesis of how this occurred. This was happening in Court 16. I believe that this court, in another case, Ex parte Warren McGee, had this issue before it as well. That was a summary reversal of the Court of Appeals on other issues, a jurisdictional issue, I believe. But it's similar of a case. There's some important distinctions, but they're similar. And I believe there's another one.
Does the jurisdictional ruling in that case affect this one?
They're similar. Well, I'm sorry, let me take a step back. No, I'm sorry, the jurisdictional ruling in McGee dealt with, I think it was they just dismissed the appeal outright. It wasn't a jurisdictional issue on the underlying, correct.
Based on the wise advice of the appellate section, they put a stop to it.
Yes, I don't want to take complete, because Mr. Bennett certainly played his part as well. But that's how a lot of this happened, and that's actually how that happened in this case, is bringing all this up to that court. The court eventually was doing this and then recognized that its show cause order was so defective as to basically be void. And that's kind of what this case at this stage in front of this court is about. Because the double jeopardy questions that I believe Mr. Bennett was getting about whether this can be double jeopardy, are you looking at what was alleged in the show cause, those weren't even addressed by the Court of Appeals. The Court of Appeals did not address that. They just found that the original show cause order was void, and therefore, because it was void, because it was a nullity, the petitioner was not actually placed in jeopardy.
Who gets to make the argument that an order like that is vague, is too vague and to be void?
Well, Judge Urey, I think that it depends on.
Does the state have constitutional rights? I'm asking you that.
The state does not have, generally speaking, the constitutional rights are against the state to protect individuals from the state. But I would say it depends on what the ultimate conclusion is. And that's the distinction between void and voidable. So if something is void, and this is black letter law, it can be attacked at any point by anyone. And this is how this usually pops up in habeas proceedings, collateral attacks on something. You see this also in sufficiency claims against protective orders, where they say the underlying protective order wasn't sufficient. In that case, those are voidable claims. You waive them in the original trial court, so you can't bring it up again. But they always try and pigeonhole it into voidness, and then courts usually dismiss it out of hand, that you can't do that.
But if this had been an indictment or an information that was left out an element or something, and the defense didn't object to it, it wouldn't be void. So, I mean, it seemed kind of unfair.
Well, Judge Keel, I think that's true to a point. So you take a look at, I think the most recent case that this court dealt with was Jenkins in 2018, when it was trying to review the sufficiency of an indictment. And there are certain things that are an indictment. And there are still, even after the adoption of Article 5, Section, or the amendment of Article 5, Section 12, there's still things that are not an indictment. The point here is, even if you were to use the test to determine what an indictment is, this show cause order would fail that resoundingly.
And yet the state pursued prosecuting her for this contempt on this order, right?
Well, so the mechanics of that were that the state did represent the state in this hearing at the behest of the judge. So the judge, and you see this when you're reviewing the record, the judge discusses how the judge had made the order and issued the order. I think he talks about it in terms of, I've refined my order based on what you, I believe he was talking to Mr. Bennett, have told me about where it's deficient. So this was the judge, primarily the actor there. But I'm not going to say that the state wasn't, the state did participate in this. I think you don't have the same sort of state action, though, as if we had brought the indictment, we had sought a grand jury, decided to file a criminal information, for example. What we did was we entered in the information, and the judge made their determination off of that. And so I think that as far as the state's involvement in there, yes, there is some state involvement, but I don't think that changes the analysis whether it's void or voidable, because it has been consistent throughout the jurisprudence of this state that the thing is a nullity. Going back at least to 1979 with the Supreme Court, they say that it's a nullity. It's as if it never existed in the first place. And so you see that as compared to a case like, I believe it's State versus George, where it's an Article 113 case about the waiver of jury trial. And there you didn't have the state agreeing to the waiver of jury trial. And so the issue is, well, was that person put into jeopardy? And the answer was no, because the original tribunal didn't have the authority to conduct the proceeding in the first place.
A period of time in the state when juveniles to be waived into the adult system had to have specific findings. And we had cases of people that didn't have those findings that had been in prison for 20 and 30 years. And those were void, right? It would have been void. So those people were never in jeopardy, though they were serving time in prison? So
I think, for example, I think you're referring to Ex parte Moon, and so I can tell you that Moon didn't have those findings, and they weren't in jeopardy. And in fact, we just retried Cameron Moon not that long ago. I think this past summer. Based off of that. Because the question is whether the court had jurisdiction in that case. In that case, the district court didn't have jurisdiction over the offense because it hadn't been a proper waiver. I know that this court has since sort of retracted Moon and certain requirements there.
But I'm asking, assume they hadn't, what would the double jeopardy implications be of having been transferred to the adult system, tried, convicted, and sentenced, and having served the sentence? So the question is whether you were placed in jeopardy in the first place, and if the district court in that case never had jurisdiction, then they weren't placed in jeopardy. I understand the implication. So they've served their sentences.
Right, and in that case, if they are subsequently convicted, then they are, in the same way that an appellate reversal can say that your original trial wasn't good enough, you can still get credit to that. But the fundamental point, and I understand that your greater point about serving the sentence, et cetera, but it doesn't change the fundamental legal issue, which is that court never had jurisdiction. And this is how strong jurisdiction is.
Well, I want to ask that, so like, what is it about the show cause order that made it so defective that it didn't deprive the court of jurisdiction, or the court never gathered jurisdiction, compared to, say, the limited circumstances where an indictment is so defective that it's not an indictment? Like, I think the one example is they don't even name the person is for an indictment. So what is the corollary to that for this show cause?
Yeah, I think the other example is if the date of presentment precedes the date of offense.
That's right.
I've, unfortunately, when I was in the trial court, ran into that. So I think since Article 5, Section 12, yes, this court has recognized that there is, in order to get a void indictment, then you are looking at a much higher level. Right. I would say that the things, okay, I would answer this in two ways. First, I think that there's just the basic level of requirements for a show cause under constitutional principles, and then I think if you were to liken this to an indictment, and I think that's the closest analogy that we have, why it would fail even as an indictment. Because
But she did object to it, right?
Your Honor, Judge Keel, I think she objected to it. I've been struggling with how to characterize this, and I believe Mr. Bennett alluded to this as well. She objected to it. There was a statement by the judge of, okay, she objected to the timing of it. I think specifically that she wasn't afforded the right amount of time. And I think Judge Jordan in response said something akin to, okay, well, I'll hold her in custody and then we'll proceed once you've had enough time, which I think was over the weekend. And so her attorney at that point withdrew his objection. I don't think he waived.
The court gave him like an option, right? Either
It was-
your client's gonna stay in jail.
It was, to borrow from the last argument, it was conditional, either or. But Judge Newell, to return to your question, so in order to have a valid show cause order, you need to allege the order, reasonably specific order, you need to allege how it was violated, and you need to allege a willful, culpable mental state. And this actually bleeds into whether this is an indictment. None of that is here. There's not even the allegation that she would be facing criminal sanctions. As Presiding Judge Schenck, you admonished the person earlier today that she would potentially be facing confinement or criminal sanctions. That's a requirement, but I don't even think we need to get there because this, and I believe Mr. Bennett agreed under Texas law that this is insufficient. I believe that we disagree about the implication. I would say that if it's insufficient to do that, then she was never.
The thing I'm wrestling with is sort of how is, if the show cause order is deficient, like, for example, get this back, when you get a reversal on appeal because of the process of the appeal, it is something dealing with something in the proceeding itself that ends up being a problem. And so that doesn't violate double jeopardy if you go back and try the person again. So is this a problem with the show cause order that's something that needed to be remedied? Or is it, how do I distinguish between this is something in the show cause order that needs to be remedied versus something that never invoked the trial court's jurisdiction?
So I think my response is kind of enmeshed with the way that contempt orders have been interpreted consistently for about 50 years, which is to declare that they're void. And this court has said that in those sorts of cases where it's a nullity, it's like it's.
Does it turn on whether the defendant asked for it?
No, I would say that's I believe where Mr. Bennett and I in our briefing disagree, and the crux of it is if it's void, then it doesn't matter.
Void ab initio.
Yes, void ab initio.
Isn't the double jeopardy guarantee one of these just simpler, light on, light off rules for the public, not so much for us nerds, right? I mean, I'm in jeopardy or I'm not in jeopardy, and when I'm staring at a judge and I'm told I got a problem and I may be confined, and then I hear that I am, later when I hear, well, I know that happened, but that really didn't happen, right? How do you explain that in a way that's consistent with the intentions of the framers and having a double jeopardy clause in the first place?
Well, so I think that's delving into the actual analysis. So forgive me if I'm going to that as well.
Well, let me push you forward because I've heard enough. Let's say I'm not with you on there wasn't jeopardy attached from a proceeding that went to a conclusion, she lost, looked bad, but you said was void. But isn't it possible under Blockberger that she had two distinct problems? She made a promise to a judge that she breached, making the judge angry, and then she violated a penal code section. That is what Judge Parker and I were talking about earlier of you're out on bond, you're not supposed to commit any more armed robberies, you don't commit any murders, and I let you go. You made a promise to me when I let you go that you weren't going to commit any armed robberies or murder people, or I was going to make you serve a long sentence for what I let you go off of them the first time. Now you've gone and done something else. Isn't that a better argument for your side of there's just not a double jeopardy bar here at all?
So I think that that's certainly an argument that we've made in the trial court. It's certainly an argument we made in the Court of Appeals. The problem and the reason why I'm hitting so hard on voidness here is because the Court of Appeals didn't address that issue. So even if you do agree that this isn't void and that she was placed in jeopardy, there's still that second, I think as you've alluded to, there's still that second portion of, are we even Blockberger precluded out? Obviously the state's answer would be no, but that's something that the Court of Appeals didn't address.
Why? Why is the state's answer no?
Because when you're doing a Blockberger analysis, you're looking at the elements of the offense and you're comparing it to the elements of the offense, right? You've got, let's say that let's make it easy and just say 2 identical offenses, right? So let's say DWI. Elements of DWI are you operated a motor vehicle in a public place while intoxicated. Easy. So those are your elements of the offense. We have 2 charging instruments that allege, let's say that they're the same dates. So let's make it super easy. And that is probably going to be a problem unless, I suppose, if you got out on bond and then drove while intoxicated again, but then you start looking at the elements or the evidence that was adduced at the proceeding. Now, why that's a problem here is because you have a show cause order that's basically saying, hey, you did a thing, and that's it. That thing being you did something and you got arrested or charged. There's nothing there to compare to. To return to Presiding Judge Shank's question about the order.
Who's culpable for the fact that it lacks specificity?
Well, I think.
Upon whom do we put that burden?
I think that the burden would be, regardless of whether it's the judge or the state. I mean, I'm the one up here arguing, right? But the implication from that is the real question, whether it's void or not. And if it's void, and like I said, I believe Mr. Bennett agreed that under Texas law, this would be. And I think that using the analogy of something like State versus George, where you have a Texas statute that governs the way of jury trial waiver in that particular case under Article 113, and this court said no. The court didn't have the authority to do that. I think if it's void, then it's void. She wasn't in jeopardy. Now, if this court disagrees, that's when this court would remand it back to the Court of Appeals for an opportunity for the Court of Appeals to do a double jeopardy analysis.
Do you have to remand? Is it a purely legal question?
So I think that, yes, I would say that the question that was granted was on the voidness one. I think I could certainly, that was the question I addressed, I should say.
That'll be up to us, I think.
I'm sorry, well, of course it would be. But I think that generally whenever there's an issue that was not addressed by the Court of Appeals, even if it's a question of law, the practice has been to remand it back to the Court of Appeals to allow them an opportunity. They didn't get to that threshold, or they didn't get past the threshold of was this void.
Is the state stopped from saying that this is void since they relied on this during, I mean, you relied on the action of the judge for her to be given this probation?
I would push back on the reliance on her being given this probation. I think if you look at the record of the hearing, this was, the state was there, the state did participate, but this was largely the judge going through and so yes, we submitted we submitted the information, but I don't know if that addresses your question.
I wanted to ask, so I guess that from a basic level, there was an order that the trial court had entered that the person violated, and that's what led to the habeas corpus, or the show cause, right?
Conceptually, yes.
Yeah. So why is it the judge lacks authority to enter or hold someone in contempt for violation of their order?
Well, because that comes back to whether the show cause order can, but let me go foundationally here.
Okay.
When you're dealing with a crime, you're dealing with something that has violated a penal statute. Everybody knows what it is. When you're dealing with a show cause or contempt, it's basically judges making up the offense at that time, right? We've got this order, and you violated.
You should have done a thing.
You did a thing. But it's basically judges acting to create an offense in a moment. Now, that offense is based off of a prior order, sure, but there are certain, in the same way that an indictment is supposed to give notice, that's one of the main reasons we have an indictment or a criminal information. That's what the show cause order, and because you're dealing with types of, for lack of a better term, I'll call it an offense, but types of conduct, types of enforcement, whatever you want to characterize it, that is fairly ephemeral outside of that order, it requires a greater level, and that's why the courts have interpreted it to be void and not voidable.
You participated in the hearing. Did at any time the state say, hey, we don't want to be here, we don't want to put on evidence, you know, this is proceeding the wrong way, and now you're here before us saying the judge shouldn't have done that, but you were the one that was presenting the evidence. So what are we supposed to do with that?
Presiding Judge Schenck, I see I'm out of time. May I respond?
Reluctantly, yes.
I think, again, I've likened this to indictments, and I would liken this to the fact that there was that period of time in the 70s and 80s and into the early 90s where defendants were coming for the first time after having participated in a proceeding, and they were able to say that something was void. I don't think that mere participation is going to change the fact, and it certainly doesn't change the fact about whether it's void or not. And with that, request that this court affirm the lower court's judgment.
Thank you very much.
Thank you.
Thank you. Presiding Judge Schenck, you asked about making the judge mad. Is there an offense of making the judge mad, right? The contempt was actually making the judge mad.
Breaking the promise.
Right, and DIXON answers the question. The state didn't brief DIXON because DIXON answers the question. DIXON is on all fours, and DIXON is DIXON and it's Foster. In Foster's case, the conduct both violated the conditions and also, with another element added, was an offense. But in Dixon's case, which was the unanimous decision, in Dixon's case, the conduct was only a violation of the contempt order because it was criminal conduct, and it was the same criminal conduct.
If you don't think contempt or her contempt for something other than the DWI that was part of the agreement, we wouldn't be here, would we? In your
No,
opinion?
right, no, she tested positive for alcohol.
Okay.
Right, no, that's,
Do you agree with the state that?
no. Oh, I'm sorry.
Hear me out. Hear me out.
Yes, you're.
That the Court of Appeals addressed this case from the perspective of deciding that the order was void and so it never had any effect at all, versus addressing it as the question of whether there is an actual jeopardy violation here, right? And I mean, it seems like you're answering one question, which is an important question, is there a jeopardy problem? And the state is answering another question. And then, of course, if we go back to what we granted review of, I think that Mr. Crump suggested that the question we agreed to answer went to the voidness question. And so I'm struggling with that a little bit because maybe, let's say hypothetically that we might agree with you about the jeopardy, but we've granted review of another question potentially. I don't want to take up too much.
I got
Go
it.
ahead, go
I've
ahead.
got it. The Court of Appeals opinion is terrible.
Okay.
It's sloppy. It's got misspellings. It's got errors in it, and so they don't really give a good reason. For example, they say no evidence, but clearly there's evidence. But the question for this court is, the de novo question is this a double jeopardy violation? Simple as. Mr. Crump took issue with my saying that this is indisputable. This is indisputable. It's indisputable, and it's indisputable because of DIXON, which again the state didn't brief, and also because of two other Supreme Court cases. Ball is one of them, and Ball was about an indictment being defective and still jeopardy attached. Now Ball's really interesting because in Ball there were 3 defendants, and one of them was acquitted. Other 2 were convicted. The 2 who were convicted appealed. The Supreme Court found that the charging instrument was defective, and the government went back to charge all 3. And the Supreme Court said, okay, it's fine to charge the 2 because they appealed. oh, shoot. I'll get it. One of you said, I think it was you, Judge Newell, talked about, but both of you, talked about an appeal. An appeal allows a retrial, of course, because the defendant's consenting to the retrial, which is not what we have here. But the two defendants who had appealed could be retried because they had appealed, but the guy who'd been acquitted, even on the defective indictment, couldn't be retried. That's because jeopardy had attached. Jeopardy had been detached or been waived for the two guys who appealed, but Ball stands for the proposition that even where the indictment is defective, that jeopardy attaches. Remand is not necessary because of DIXON. The court can look at DIXON and can see that Blockberger is satisfied when the contempt order incorporates the entire penal code and there's an allegation of violation of a particular penal code section, just like this. It was Judge Newell who had asked about the appeal. He can be retried because of the consent. There are two possible U.S. constitutional objections. I didn't hear the state talking about any constitutional problem with the contempt judgment. The two possible objections are the Fifth Amendment and the Sixth Amendment. Fifth Amendment, due process, we know that can be waived. Right to double jeopardy, right? That's the problem. The Sixth Amendment requires that the defendant be notified of the nature and cause of the charge against him or her. She was notified. If she wasn't notified in the show cause, she was notified when the state presented its evidence, because it was after that she said that her lawyer said, okay, we'll proceed. At that point, when he decided, okay, we'll proceed, he already knew. Not only did he have notice of the nature and cause, but he'd seen the state's entire case. So there's not a Sixth Amendment problem. There's not a Fifth Amendment problem. The state hasn't proposed any other sort of U.S. constitutional problem. And so we're talking about a red bow tie. Now, do we agree that the bow tie wasn't red? Yes. However, we waived the red bow tie. The state talks about how it's void. Presiding Judge Schenck, you asked about juvenile cases. The case is Hong, H-O-A-N-G. It's 872 Southwest 2nd, 694. I think we both briefed it. Hong would turn out differently today, because in Hong, the district court did not have jurisdiction over the juvenile, and so was allowed to be retried on cases that he hadn't tried to reopen. Outcome would be different today. And what that proves is that we have to follow U.S. constitutional rules in deciding double jeopardy, because it doesn't make sense that the same case with the same facts, the same procedures would come out differently in Hong, I don't know how long ago it was, 25 years ago, would come out differently today on double jeopardy than then, without some Supreme Court change in how double jeopardy has happened. Is how double jeopardy works. The only thing that changed is the red bow tie. That the state changed the bow tie rules for juveniles so that now you have to object to being prosecuted in adult court, and so Hong would come out differently today. Illustrates that we have to follow U.S. constitutional rules because that's the bedrock, right? That's double jeopardy. Why we don't say double jeopardy unless no red bow tie. We say double jeopardy. Earlier today, somebody talked about the state playing fast and loose with words. This is a really interesting thing for me, and I think if there were nerds on the court, they might appreciate this. We have for decades misused the word void. A contempt judgment is void in the sense that it's subject to collateral attack. Void doesn't mean void ab initio. Void means it's a term of art that means subject to collateral attack. The court can look at... Including
when it's a subject matter jurisdiction issue?
That would mean it's voidable. Voidable, yeah.
We think, right, the common use of the word is voidable, but this is a term, let me get with you in just a second, please. But it's a term of, void is a term of art that means subject to collateral attack. Look at Rhodes v. State, which is 240 Southwest 3rd, 882.
Subject to collateral attack forever.
Subject to collateral attack, yes, forever. But that's not a constitutional principle, because under the U.S. Constitution, you could lose your right to file habeas within a year. That's the Anti-Terrorism and Effective Death Penalty Act. By Texas procedural rules, sure, except for latches, right? So subject to collateral attack, except for latches. Ex parte shields is another case from this court where this court talks about void being subject to collateral attack. There are others as well. It's the appellant's burden on collateral attack to show that the judgment is not valid. Okay, so jurisdiction. Jurisdiction exists. Jurisdiction, and there are this court's cases saying this, jurisdiction is something that the legislature gives to the court. The charging instrument doesn't give the court jurisdiction. The charging instrument invokes the court's jurisdiction. And what Article 5, Section 12 of the Constitution says is that the charging instrument gives the court jurisdiction over the cause, which is not subject matter jurisdiction. Subject matter jurisdiction exists regardless. If in Nix, this court gives the example of lack of subject matter jurisdiction. For example, a county court that is that hears a misdemeanor involving official misconduct. That's a lack of subject matter jurisdiction because the legislature said no subject matter jurisdiction. And sure, in theory at least, that's something that's not forfeitable and it's not waivable, but under the U.S. Constitution and under the U.S. Constitution, you can waive the Fifth Amendment rights, you can waive the Sixth Amendment rights. That's not a U.S. constitutional principle that the invocation of subject matter jurisdiction, which is what the charging instrument does. So look for the words invoke subject matter jurisdiction.
Is there a distinction to be drawn between authority and jurisdiction in this case? The trial court's authority to do what it did versus the trial court having jurisdiction, subject matter jurisdiction?
I think so.
Okay.
I think so. I think the subject matter jurisdiction is Government Code 21.001, which is contempt. And I think maybe the authority lacked the authority to do what it did because bail conditions can't be enforced by contempt. But that's a red bow tie, right? So Mr. Crump says, "Oh, it's void." No, that's a red bow tie. That the U.S. Supreme Court doesn't care. The U.S. Constitution doesn't care whether the bow tie is red. The U.S. Constitution cares whether this person was actually in jeopardy. And then there might be some U.S. constitutional exceptions to that, but none of them apply here.
Thank you for your argument.
Thank you. We pray that the court reverse the judgment of the Court of Appeals and render a judgment in favor of Ms. ESTEVEZ. Thank you.
Appreciate the very fine lawyering from both sides. Fun to hear it. Thank you. We will now stand in recess.
All rise. Oyez, oyez, oyez. The Honorable Court of Criminal Appeals now stands recessed, subject to the call of the presiding judge.
Yeah.